Mr. McLean? Courtroom 2, I'm gonna call 2391 so Mr. McLean can talk to his client, okay?
No, not 91, 92. And he's not in the courtroom yet. He stepped out for a minute.
Okay,
So call 92, not 91.
okay, thanks.
Yep.
Good morning, ladies and gentlemen. My name is Judge Law, and we're going to begin with the state all-purpose calendar for today, April 18th, 2023 at 9 a.m. The calendar is being handled predominantly through Zoom. Most of the individual cases that we'll be addressing are with folks who are at the Fulton County Jail. This is a list of misdemeanor criminal cases in which individuals have already been accused, bonds have been set, certain folks were given a reset date, and others may have been released from bond already. In either event, when I call your case, we will be addressing it on an individual basis to see whether you want to consider a plea offer recommendation from the state and enter a plea in this particular case, in your particular case. Or if you'd like to enter a plea of not guilty, in which case your case will be arraigned. It will be reset for a trial to be scheduled at a later moment. Now, if you are a defendant who is charged with one or more misdemeanor offenses, please remember that you have a right to remain silent. Anything you say in open court, the statements can and will be used against you. We may be handling court virtually through the Zoom format, but please keep in mind that everything that is going on is being recorded and live streamed. So I would recommend that you do not say anything unless you speak to your attorney. You have a right to an attorney. If you cannot afford one, one will be appointed to represent you either from the public defender's office or the conflict defense list. FYI, position 48, Mr. DeQuanix Wood, has been released. And he's in the courtroom. So we've recommended that he update his address, and then he will be sent a later court date, either by the Orca calendar or by Judge Roth, case manager. All right, did you hear that, Mr. Isaiah? Oh, he's fallen asleep.
No, I'm not falling asleep. My name is Isaiah, and that's the formal name. But you said I have a new court date?
You don't have a new court date yet. You've just been released on your bench warrant. So there's no warrant now existing against you, but you still have an active case against you. All right. Every time you change your address, you must let the clerk's office in this building know, because we only send notices out whatever address we have on the system.
So
We don't keep up with the post office.
Is there a victim in this case?
Yes, sir.
Okay,
You're charged with maintaining a disorderly house.
Okay, so the victim writes the affidavit, like, do I still have to come to court?
You're asking me legal advice. I would recommend you hire an attorney or speak to the public defense counsel.
Okay, so
We're going to provide you a form. You need to provide us with your current address, your phone number, and your email. All right.
Then y'all will send me the information for the new court date.
Yes, as soon as we update the system.
Okay, one more question. So for this FTA is lifted off of me, right?
Correct.
So I can go deal with the DMV to get my driver's license?
Yes.
So, okay.
All right. Are we addressing ACDC at South Annex first?
Yes, Your Honor, good morning.
Good morning.
Before you is Ms. Pugh, position 31.
All right, thank you. This is Katrina Pugh, P-U-E, case number 19 CR 0060488. Ms. Pugh, you've been advised of your right to remain silent, and your attorney is going to be Mr. Derek Howard. Do you see Mr. Howard on the screen?
Yes, Your Honor.
Gentleman in the bow tie? Yep, okay. All right, and Ms. Pugh's is position 31. This is going to be a negotiated plea hearing. Ms. Pugh intends to enter a NOLO plea. Ms. Pugh, may I place you under oath?
Yes, ma'am.
Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. Mr. Young, good morning. And what's your recommendation?
Good morning, Judge. The state's recommendation on this case is 12 months served, 15 days in jail, credit for time served, 8 days, the balance suspended, and stay away from all Target stores.
All right. Mr. Howard, are these the terms to which your client has agreed, and do you stipulate to the factual basis, venue, and ID?
We do, Judge.
Ms. Pugh, have you consumed any medication or alcohol?
No, no, Your
And
Honor.
have you understood the proceedings so far?
Yes,
Are you satisfied with your attorney?
yes, Your Honor.
And has anyone forced you or induced you to take this plea today?
No, Your Honor.
Has it been explained to you that if you decide to plead no contest to this charge, that you would have to give up your constitutional right to a trial, to not be able to confront your accuser, examine witnesses, and have the state try to prove the charge against you beyond a reasonable doubt? Has that been explained to you?
Yes, Your Honor.
Are you prepared to give up these rights?
Yes, Your Honor.
How do you plead to one count of theft by shoplifting?
No, no.
Your sentence is 12 months to serve 15 days in jail, credit for time served 8 days. Your time at the Fulton County Jail is completed for this case. The balance is suspended. And once you're released, you are not permitted to return to any Target store. If you ever want to go back shopping there, you need to call them and see if they allow you to go back. All right?
Yes, sir.
But I think for at least a year, you won't be able to return. Thank you.
Thank you.
Thank you, Judge.
Position number 12, Ms. Gary.
Next one.
Position 12, 1-2, Ms. Gary.
Ms. McLeod, that is going to be your case, yes?
Good morning, Your Honor.
Good morning. You have State versus Bridget Gary, case number 23 CR 0020308. Ms. Gary has been accused of battery from April 2nd, 2023. Ms. Gary has been advised of your right to remain silent, and your attorney is Ms. McLeod. Do you see her on the screen?
Yes.
All right. Ms. McLeod, how are we proceeding?
Your Honor, I haven't had a chance to speak with her yet.
Okay.
I would ask the court to give me that opportunity, and then I will be able to say how we're going to be proceeding.
All right. Have you had an opportunity to speak to Mr. Robert Gillen as well?
No, Your Honor.
Okay. Deputy Milton, we'll need a number at where you're located, and if you can put that in the chat to Ms. McLeod. And courtroom 2, do we have position 13, Robert Gillen in the courtroom as well? All right. So eventually, Ms. McLeod, you will need to contact the jail to have a little conference. The
Yes.
number at the jail is 404-612-2392.
And Judge, just by way, I was not aware, I didn't see an entry or anything that indicated that she was represented by Ms. McLeod. So I actually met with Ms. Gary at ACDC and had detailed discussions with her. So if she's a conflict for office, then I certainly.
I don't know that she is. I just heard that I'm representing her. She was not on the list of people who I thought I was representing.
Oh.
So
Okay.
you've already spoken to her.
We have position 12, 13, 28 listed as conflict.
Okay.
So
I can-
if y'all want to verify,
Okay, we can do that. I can see what the basis of the conflict, if there's a conflict, and if not,
Okay.
then I've spoken with Ms. Gary, but
all right. So 12,
we'll check.
13, and 28, please verify whether Ms. McLeod is the correct counsel of record for the defendant. And then I can go back to those cases. Who do I have right now?
Ms. Duvall. Position 10, Ms. Duvall.
All right. This is Bianca Duvall. She's got 2 cases, position 9 and 10. Position 10 is a bench warrant. For position 9, the case number is 21 COB 000054. The allegations are discharge of a firearm at or near a public highway or street and criminal trespass from October 19th, 2020. Position 10 is a bench warrant ending with 23 FTA 300. And okay, let me go ahead and do this. This is positions 9 and 10. Counsel is going to be Mr. Dodis, is that correct?
it'll be me, Your Honor.
Oh, Mr. Howard, okay, I do. And Mr. Howard, how will we be proceeding in these cases?
There's just gonna be a not guilty, and I can either submit a written waiver of arraignment or the court can do an arraignment without us having to read the accusation. I provided that to her and went over it with her yesterday.
All right, go ahead and submit a waiver of arraignment and you
Okay.
can direct that to Ms. Casey Strong.
Okay, all
Right,
right.
right. And so I'm going to note this, Ms. Duvall, your attorney is going to be filing a not guilty plea to the charge brought against you. And the case is going to be further noticed for jail jury. Please be sure that your address and contact information are correct with the court clerk's office at all times. If you change your address, if you move, if you're hospitalized or detained elsewhere, you need to make sure that someone reaches us so that no future bench warrants are issued against you for failure to appear. Position 10, Mr. Howard's going to address a request to set aside the bench warrant. Mr. Howard, the bench warrant's already been executed. I'm assuming that's why she's currently incarcerated at the jail.
Yes, Judge.
So there's really nothing for me to set aside, but I'll be glad to hear your argument on bond. Ms. Duvall, please keep in mind that you have a right to remain silent and you're, okay, go ahead.
Yes, Judge. Ms. Duvall is a lifelong Georgia resident. She was born and raised right here in the metro Atlanta area. She's a graduate of Douglas High School. She actually currently works for the Varsity over on North Avenue. She's been with them a total of 15 years. They stopped operations during the pandemic, but once they restarted, she has been re-employed with them for the past 2 years. And she's certainly concerned about being able to get back to work. And she does have 6 children, Judge, 5 of which are minors. And her youngest is only 6 weeks old, who she nurses as well. So she's very concerned about being away from her youngest child as well as her other children that she tends to, and she's the primary or the sole caretaker for those children. So family is helping out now, but she certainly wants to get back to be able to, to be there for her children. Judge, I do show that she missed January 4th, 23 final plea calendar in Judge Basson's courtroom. I see that the notice that was sent for that court date was sent to 532 Cleveland Avenue, which is the address where the allegations stemmed from in October of 2020. However, Ms. Duvall moved away from that address a few years ago. And since December of 2020, she's been living at 3300 College Street, apartment 8, Atlanta, Georgia, 30337. That is the address that is currently listed on Odyssey as her current address. However, the notice, if you look at the notice itself, it was sent to that 532 Cleveland Avenue address, which is why she didn't receive it. So Judge, it's our position that she didn't miss court willingly. She never received the notice. It was sent to an address other than the address that's showing on Odyssey as her current address now. So we would ask that this be dismissed, the set aside or signature bond on the $32,000 fingerprintable charge that's showing on Odyssey, that's showing on the calendar today. Judge, she denies these allegations, and which is why she's wanting to get out so that she can contest these charges. She tells me she's spoken with the business manager for the apartment complex, Ms. Carmichael, as recently as yesterday, and Ms. Carmichael acknowledges that this is something that got out of hand, and that she tells me that Ms. Carmichael will acknowledge that she's not the person responsible. Ms. Duvall has actually seen the video in question. And she indicates it's not her. She has a person on a black hoodie or something, but she denies that she had anything to do with this. And Judge, she's been in custody a total of 20 days with the FTA, as well as the original 6 days that she served. So we would ask that a signature bond be given on the position 10 or otherwise dispose of it in a way that she would be released so that she can come and fight this court, from the street.
And
This case from the street, Judge.
All right, thank you. Ms. Duncan?
Your Honor, the state would obviously be against that. This defendant is currently on a $32,000 surety bond for the discharge of a firearm at or near public highway or street in a criminal trespass charge. This defendant does have a lengthy criminal history that does include some violent arrests as well as other FTAs. And this defendant also has an open aggravated assault case with a weapon, which is scheduled for final plea in May of this year. She's currently out on a $10,000 straight bond for that. The victim is a different victim, and she is alleged to have struck that victim with a wrench. And in this case, Your Honor, she is alleged to have gone to this leasing office with her 13-year-old daughter, minor ND, walked around that leasing office and took out a visible handgun at that time and shot into that office, 3 times with that firearm, Your Honor. Given this defendant's history, we do not think that at this time it would be appropriate to lower that bond, given our concerns for the risk of reoffense and the danger to this particular community and that minor who was present during these alleged offenses. Given that our policy is that if the bench warrant be set aside, we'd ask that it go back to Judge Besson. But given these allegations, the history and the offenses alleged and those dangers that are currently present in this case, Your Honor, we do believe that that $32,000 bond is more than reasonable in this case, given that she did miss court. And as the court and Your Honor knows, it is the defendant's responsibility to keep their address updated. And defendant is generally made well aware of that at the time that they are granted bond, especially since there's an additional offense with a 22 SC 185294. She was made sure to have to keep her address updated. So we believe that the bond should remain as set, and we ask that that bench warrant be returned to Judge Benson.
Mr. Howard,
Yes.
so she was working for the last couple of years at Varsity, but she never updated her address?
No, Judge, the address on Odyssey is her correct mailing, is the correct address. The address that the notice was sent to is wrong, though. It's not the address that's on Odyssey. That's our issue. She was out on bond on this. A notice was sent to an address other than the address that you see on Odyssey as her address, which she acknowledges has been her address for the last several years.
The
but-
apartment 8 address?
Right, and if you look at the notice, it was sent to 532 Cleveland Avenue, which is the apartment complex that's indicated as the alleged, where the alleged incident took place. But so it's our contention she didn't receive the notice because it was sent to the wrong address other than the one that's on Odyssey. So that's the reason we're asking that she be given a signature bond, Judge. Aside from any other history, she was out on bond on this. She didn't do anything other than what she should have done, which is respond to a notice. If it had been sent to her proper address, she would have been able to be in court, but it was not. It was sent to 532 Cleveland Avenue. It shows return to sender, and you can see that actually on Odyssey.
All right, let me see that.
And just for clarification, Mr. Howard, this is Anna Allen, supervising today for the ASG's office.
Yes.
Was an address updated with the court when this young lady moved? You keep saying their address in Odyssey.
No, the allegation is that the address has always been correct, that the notice for the
Right.
hearing for Judge Besson was sent to the address of the incident
Right.
as opposed to the defendant's actual mailing address. And I'm
Right.
looking at Odyssey.
Both things were actually stated by Mr. Howard, that she
Okay.
moved
Correct.
and that the address in Odyssey for this young lady is the address where notice was sent.
So
Mr. Howard has
Oh,
not
well,
said.
Well, maybe,
Just one
maybe-
second, please.
Yeah.
Folks, just one second. Folks, just one second. Yes, Mr. Jordan.
So her address was updated by the jail on 4/5/23 when she was booked into the jail.
To the college.
Right, it was updated on 4/5/23 by somebody named Candace Perry out at the jail when she was booked into the jail.
What was the previous address?
Previous address was listed as 532 Cleveland Avenue, and that's why the notice was sent to that address.
All right.
So we didn't get her current address until she was booked into the Fulton County jail.
Right, and that's why it's interesting that the statement is the address in Odyssey is her current address, but the notice went to the old address, not she moved, not she updated the court with her address. That specific piece is missing.
And I
That's
also,
why I asked.
would like to add for the Superior Court case, I don't see a change in address for that case as well. She is out on a 10K straight bond for that case.
Which one?
The 22 SC 185294, which is aggravated assault, which is,
Judge Ingram set aside that bench warrant.
okay. I don't see a change in address, however.
All right. Mr. Howard, now you have the last word.
Judge, she didn't get notice. Which is why she didn't appear. There was not, all bench warrants aren't created equal. She wasn't trying to abscond or somehow trying not to appear in court. She didn't receive it. It was sent to an address other than the address she currently lives at. I don't know that there's a history of failure to appear. I didn't hear anything related to that. So I would ask the court.
I can verify that also with pretrial. Who's our pretrial officer this morning?
I'm here, Your Honor.
Ms. Tyson? Yes.
Yes. It appears she has 3 FTAs. Failure to appear. April 2016 out of Fulton County. Second one is out of Jonesboro, March 2023. And another one out of Fulton County. And that's the same day actually as the arrest, the April 2023 FTA that we're talking about now.
Yeah. Ms. Duvall, I'm looking at your criminal record history just on Fulton County's case management system. And it's concerning that you've had quite a few cases with us. And you are not a stranger to the fact that you must always have a current address with our clerk system so that we can send you notices. I'm reading the pretrial report and the intake documents of when you were arrested for this case in 2020, and the Cleveland Avenue address was the only one provided.
I gave it to my lawyer. I gave my address to my lawyer.
That's the address that was on file. That was the address that was provided. And if that's the address you provided to your lawyer, that's the address that was on file.
I gave them College Street, Your Honor, and the aggravated assault case is not mine. Like, we was gonna get that squared away May the 10th. I didn't do that.
Ms. Duvall, the aggravated assault is yours.
No, I'm saying like I wasn't the one that hit me. Like,
Ms. Duvall, just
it just all of us was out there and they took me to jail. I wasn't
Bond
the one
is
that hit
bond
me.
is amended to 7,500. It's a straight bond, no contact with the victims, and she must appear in court for all outstanding cases. She needs to come down to the clerk's office and reaffirm her address. And Mr. Howard, I'm not certain what happened, but all the addresses from the intake documents for the discharge of firearm case reference a Cleveland Avenue address.
Your Honor, what is the scrape bond?
It's a surety bond.
And Your Honor, could you provide the breakdown for that?
Oh. Sorry about that. And you're talking about, yeah. So this is the bond that was set on the bench warrant, and I'm amending that to the discharge of firearms to 5,000, the criminal trespass to 2,500. Request to set aside the bench warrant or to reinstate an old bond are denied. Just 1 second, please. I've just been advised that since the bond is on the FTA case, it's just one bond. You don't need a breakdown for that.
Okay.
All right. Thank you. Next case, please.
Thank you, Judge.
Position 16 and 17, Ms. Jerome.
Who is speaking, please? Who's the case?
Position 16 and 17.
Okay.
Her name is Jerome, Jayroe.
This is Kylie Roe, 20 CR 001-930F. Ms. Roe was cited for cruelty to animals on December 9th, 2019. She has a bench warrant that was issued on September 26, 2022. 23 FTA 294. Ms. Roe, you've been advised of your right to remain silent, and your attorney is Mr. Derek Howard. Is this a negotiated plea?
Yes, Judge.
All right. Mr. Roe, if the plea hearing moves forward successfully, then the bench warrant case will be null pros. In other words, we will not pursue that case and it will be closed. Please raise your right hand for purposes of the plea. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes. I do.
Thank you. Ms. Duncan, what's the plea offer for position 16?
Yes, Your Honor, the state's offer in this case for the count of cruelty to animals is 12 months to serve, 26 days, credit for time served, 13 days, with the balance probated, complete the bark BARC animal cruelty online course within 60 days, a $500 fine, or 50 hours of community service. We're asking that this defendant not leave that subject dog or any dog unattended at any time, and we are amenable to probation terminating upon completion of the terms.
Okay. Mr. Howard, I tried to write down everything she said, but are those the terms to which you've agreed?
Those are the terms, Judge, and we do stipulate to a factual basis, venue and ID in this case. We would ask that the probation fees be waived to allow her to use any monies to pay for the BARC course. And I would inquire if probation has the information to provide to her about how to complete that course. I know that the prosecutors have to do something on their end to enroll Ms. J. Roe in that course, but I just wanted to be sure that probation has the proper information so that she can get that course done within the 60 days as required. And we are asking for the 50 hours of community service as opposed to the $500 fine.
So she's doing the 50 hours of community service.
Yes.
All right, so the request for probation waiver of probation fees is denied then. All right, Ms. Jarreau, have you consumed any medicine or alcohol?
No.
And have you understood the proceedings so far?
Yes.
And has anyone forced you or induced you to take this plea?
No.
Have you understood are you satisfied with your attorney's representation?
Yes.
Has it been explained to you that if you decide to plead guilty to the charge, that you would have to give up your constitutional right to have a trial in front of a judge or a jury, to be able to confront your accuser, challenge the state's evidence, present any defenses that you may have if you choose to do so, and have the state try to prove the charge against you beyond a reasonable doubt? Are you prepared to give up these rights?
Yes.
How do you plead to one count of cruelty to animals?
Guilty.
Your sentence is 12 months to serve 26 days, credit for time served 13 days. You don't have any more jail time for this case. You will be reporting to probation next Thursday at 132 Mitchell Street. That will be listed on your discharge documents. You will need to enroll in a course called BARC Education. That's BARC education.org. And you would need to complete that class. Well, you need to enroll in that class within 60 days of being released. You will be doing 50 hours of voluntary community service at any nonprofit agency except a school or a religious organization. If you complete the BARC course, the 50 hours community service, then your probation will terminate. At all times, while you have a pet, you shall not, like a cat or a dog, well, mostly a dog, you cannot leave the dog outside unattended. It must be leashed and within the compounds of your home. So if you have a fence, that's fine, but if there's no fence, it must be leashed or it must be in your company at all times. Understood?
Yeah.
All right. Anything else, Mr. Howard? Position 17 is now crossed. Thank you.
Judge, I did have one other thing
Yes,
that we just, for clarification, the number of days served should be 22 days. In the off chance she doesn't get 2-for-1 credit, just want to make sure it's clear. She served 2 days initially and then 11 days on a rearrest, and then she served 9 days on this, this time. So it's a total of 22 days credit that she should be getting.
So I'm going to rephrase that to serve 26 days, credit for time served 22 days, so
Yes.
jail time is complete.
Yes. Thank
All
you,
right.
Judge.
Thank you.
Mhm.
Who do we have, please? Is that Miss Gary, was it?
Well,
Yes, Your Honor.
we haven't had time to check, because we've been doing cases, Judge. I'll need to.
Okay, we can't address Miss Gary until we verify that she's not represented by conflict. Is there anyone else I need to address at ACDC?
It's the last one, Your Honor.
All right, Mr. Howard, if you could let us know as soon as possible if Miss Gary, so that we can complete the cases at ACDC.
Okay.
While we're waiting, courtroom 2, who do we have?
Good morning, Judge Law.
Morning.
We have position number 23 and position number 24, Calvin McKinney.
Thank you. This is Calvin Jermaine McKinney, accused of simple battery domestic violence in case 22 CR 007J from a January 21st, 2022 incident. The second case, 24, is a bench warrant 23 FTA 98 that was issued on December 15th, 2022. This is going to be a plea hearing, and if we move forward with the plea, then position 24, the bench warrant will be null prost. Mr. McKinney, you've been advised of your right to remain silent, and your attorney is Mr. Dotis. Is that correct?
Yes, Your Honor.
Okay. Mr. Dotis, are we going to move forward with this plea?
Yes, Your Honor. This should be a plea. We do have two concerns. We want to make sure the jail time is listed correctly. Mr. McKinney is currently being held on an FTA where he has 71 days of credit. So we want to confirm that that credit goes to the charge, and so that he has no additional jail time. Additionally, we have an issue with the stay away. Mr. McKinney tells me that is not the alleged victim's address, and it's actually his mother's address. So instead of a stay away, we'd ask for a one-time sheriff's escort to confirm that the alleged victim does not reside at that property, so a stay away would not be necessary.
And Your Honor, just to clarify, the state made its offers in these positions based off of the days served on the underlying offense and separated it based on the time served on the FTAs. And it's indicated in the documentation that both parties, the victim in this case, Mr. Ford, and the defendant, were both living in the garage of the mother's home. So it's our position that we would ask for that stay away.
And again, Your Honor, that's why we just asked for the sheriff to confirm that the alleged victim does not reside there. Regarding jail time, Mr. McKinney was before this court on February 14th. The offer was serve 8 days, credit for 4 days, so it was a time served offer. Then, and I think it should be now, he has been sitting in this FTA for this case. So it's our understanding that it's always that you always get the credit for the FTA when it's a related charge. And that's if Michael Jordan or someone from the court wants to chime in on that, we just want to make sure that Mr. McKinney gets that credit.
All right. I'm just going to digress a minute. Mr. Howard, Bridget Gary was represented by Ms. McLeod on April 3rd, 2023. So if Deputy Melton from ACDC is present, Ms. McLeod would need a number so that she can speak to Ms. Gary and see how they would like to proceed. And Mr. Howard, if you want to confer with Ms. McLeod as to what y'all discussed, that would be great. Going back to Mr. McKinney's case, I'm looking at the intake information. I'm not certain what happened the last time, but Mr. McKinney has been in custody for 71 days. So if you all want to modify, I can amend it to 12 months to serve 71 days, credit for time served 71 days, and move forward from that point. Mr. Dotis?
Your Honor. Thank you.
I'm sorry, repeat.
Sorry, that's my understanding. That sounds fine to us. I'll wait to hear from Ms.
Okay. And then the other part about stay away, I need the incident location. He can go back there one time with a police officer to verify that the alleged victim, Larry Ford, no longer resides there. And then he may visit or live at that property, depending on how mom feels about it.
The incident location is 6485 Cedar Hurst Trail. That's CEDAR Hurst, HURST Trail.
So it'll be a one-time escort visit. Otherwise, he has to stay away. Would that be satisfactory, Mr. Dotis?
Yes, Your Honor. Thank you for helping clarify that.
All right, moving forward with the plea.
Go back through the stay away.
Yeah, I will. All right. Moving forward with the plea, Mr. McKinney, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
Listen to my question. Look at the screen, sit up straight, put your hands down, and raise your right hand. Now raise your right hand. Do you solemnly swear and affirm that the testimony you provide will be the truth to the best of your knowledge?
Yes, yes.
Do you understand my question, Mr. McKinney?
You can't repeat it one more time.
Do you swear that whatever you say will be the truth?
Yes, ma'am, I swear everything be true.
All right. Miss Allen, what's the plea, or Miss Duncan, excuse me, what's the plea recommendation?
Yes, the plea recommendation in this case, Your Honor, we had 12 months to serve, 30 days, credit for time served, 4 days with the Family Violence Intervention Program. The balance probated, a stay away, no further contact with Larry Ford, and no alcohol, drugs, and weapons. And we were agreeing to no cross the FTA if guilty on the simple battery family violence.
All right, and based on the information we have, the court is amending that to serve 71 days, credit for time served 71 days, and then balance probated. All right, Mr. Dotis, are these the terms to which your client will accept?
Yes, Your Honor, and we do stipulate to the factual basis, venue, and ID for the purpose of this plea. We would request this court to waive Mr. McKinney's probation fees. He will need time to get a job and get back on his feet. So if Your Honor would be willing to help Mr. McKinney out, and if we could switch him to non-reporting status upon completion of the FVIP program.
I will waive probation fees for April, May, and June. He will need to get a job by July, and he will start paying probation fees. And no, he will be reporting every month.
Thank you, Your Honor.
All right. Mr. McKinney, I'm going to ask you some questions now. You need to listen to the question and answer the question with yes or no. And if you don't understand the question, then you need to say, I don't know. Okay? Have you consumed any medication or alcohol recently?
No drug.
And have you understood what's been going on so far? I can't hear you.
Yes, yes.
Are you satisfied with your attorney?
Yes.
Is anyone forcing you to enter a guilty plea today?
How about enforcement?
Repeat.
How about enforcement?
If you decide to enter this plea, you would have to give up your right to go back to court and have a trial. You will not confront your accuser. You will not be able to challenge the state's evidence, present any defenses, examine witnesses, and have the state try to prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes.
How do you plead to one count of simple battery domestic violence?
Yes.
Your sentence is 12 months to serve 71 days, credit for time served 71 days. Upon being released from the Fulton County Jail, you will have to report to Fulton Probation. While you're in probation, you need to complete a 24-week domestic violence intervention program. Those are the classes that are weekly, and you have to pay for those classes every week. While you're on probation, you have to have no contact with Larry Ford and not consume any alcohol, drugs, and not possess any weapons or any firearms. If Larry Ford does not live at 6485 Cedarhurst Trail, you may return to that location if the homeowner allows you into the property. So therefore, you need to, on your first visit, you need to have a police officer with you and go to that house and confirm whether Larry Ford lives there, and also confirm whether you are invited back in that property. If it's Larry does not live there, but your mom doesn't want you back, you have to stay away. Do you understand?
Yes, I understand.
Probation fees are waived for the first 3 months, April, May, and June. And then after that, he'll need to start paying probation fees. Probation will continue for the rest of the sentence. Thank you.
Next, Your Honor, we have position number 27, Mr. Parker, Winning Parker. 27.
Mr. Dotis, is this still a non-negotiated situation with the probation matter?
I believe so. This is Attorney McLean's case, so I'll let him address. He's walking over.
Okay. This is Wenan Parker, 23 CR 002-025J. Mr. Parker has been accused of criminal trespass and damage to property on April 1st, 2023. This is allegations of damage to modern property and a request for restitution. And not sure if he's got any other holds. Ms. Tyson, do you know if Mr. Wenan Parker has any holds?
Let me check, Your Honor. 1 second.
Your Honor, those were named in the, those were mentioned in the plea bargaining.
Okay, I see a Carroll County hold and a Dunwoody hold.
Correct, Carroll County and Dunwoody.
Okay,
Yes, that's correct, Judge. Carroll County and Dunwoody.
okay. Mr. Parker, you've been advised of your right to remain silent, and your attorney is Mr. McLean. Mr. Young, this is a non-negotiated plea. You can articulate your recommendation and the alleged factual basis to support the recommendation.
Your Honor, what he's asking for is that instead of being.
Oh, no, not Mr. McLean, Mr. Young.
Oh, I'm sorry.
Prosecutor.
I'm sorry. Go ahead.
Yes, Your Honor. The plea record in this case is 12 months served, 30 days, credit for time served, 17 days, balance probated, and stay away from all mortar property, and restitution of any, and release to foreign county holds.
All right. And is there any restitution at this present time?
Not to my knowledge. I checked our, and the factual basis is that on this day, he set fire to several trash cans located at the said incident location of Lindbergh, Marta.
Okay. And Mr. McLean, this is a non-negotiated plea. You want the probation element removed and have him just released to the holds. Would that be correct?
Right. He just wants time served without the probation, Your Honor, because he says he talked to the police officers at the time. I know what I'm about to launch into is a worthless in the sense of being hearsay, having no probative value. But he says, you know, the police told him, well, you didn't really set fire, whatever. So we'll give you a $200 fine. And then all of a sudden, because of the holds, he couldn't get the $200 fine in the minor court. He had to come over here because he had the holds anyway. So that's the anecdote I heard, third party, Your Honor.
All right. I will accept the defense position. I will do 30 days, credit for time served 17 days, balance suspended. Stay away from all martyr property in accordance with any martyr suspension. There's no restitution at the present time, but he can only be released to the outstanding holds at the present time, which would be either Carroll County, Dunwoody, and or both.
Certainly, Your Honor. Thank you very much.
Yes, Mr. Young? Mr. Young, did you have something to add?
Oh, nothing further.
Okay.
I'm sorry.
Where's Mr. Parker going? Is he off tomorrow now?
He's off Carroll County. He told me to get up. No, I was saying you're done. Oh, okay. You done, Parker? No.
Mr. Parker, have you consumed any medicine or alcohol?
No, ma'am.
And have you understood everything so far?
Yes, ma'am.
Are you satisfied with your attorney?
Sure.
And is anyone forcing you to take this plea?
No, ma'am.
Has it been explained to you that if you take this plea, there will be a conviction on your record and that you would have to give up your right to a trial, to go back and confront your accuser, challenge the state's evidence, and have the state try to prove the charge against you beyond a reasonable doubt? Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to one count of criminal trespass causing damage to property?
Guilty.
Your sentence is 12 months to serve 30 days, credit for time served 17 days. Balance suspended to stay away from all martyr property in accordance with any active suspension you have against you. And today you can only be released to the Carroll County or the Dunwoody hold. Whoever beats us to the punch, they get you.
Yes, ma'am.
All right, thank you.
And apologies, Your Honor, for giving him the impression to jump up.
That's all right. I was just wondering whether I was done. All right, thank you. Okay, Miss Gary at ACDC, Ms. McLeod, are we ready to proceed?
Your Honor.
Are we ready to proceed?
Yes, Your Honor. With Ms. Gary? Yes.
Yes, okay.
Your Honor, this is going to be a non-negotiated plea.
All right. Calendars unusually big today. All right, Gary, excuse me, Miss Gary has been advised of her rights. The case is 23 CR 002-0308, and it's been clarified that she's represented by Conflict Defense Counsel, Ms. McLeod. This is going to be a non-negotiated plea. So, Ms. Duncan, if you'd like to give us the plea recommendation and the basis for it.
The state's recommendation in this case is 12 months to serve, 45 days with the balance, well, credit for time served 17 days with the balance probated. Stay away from the incident location, no further contact with the victim, and 4 weeks of anger management. This is section 12. So the factual basis for that recommendation is that on April 2nd, 2023, officers were dispatched to 355 Peachtree Street for a fight call. They met with Alfonso Glass, who was a security officer, and stated that an unknown female, later identified as this defendant, came to that location and made contact with another person by being aggressive and combative. It was stated that by the security officer that the unidentified lady, who was later identified as this defendant, pulled out her pepper spray and released the pepper spray and then fled from the scene. It's indicated that this officer was clearly wearing a security shirt, and officers were searching. They received a 911 call and advised that that same individual, which is this defendant, had returned to that location. Officers stated that the defendant later told them that she was spraying because she was scared, but provided no other clear reason as to why she was scared, Your Honor. We do have some concerns given this defendant's history. She has 19 cycles out of Florida, so we have concerns about her ties to the community, as well as her risk of reoffense. She has several FTAs out of Florida and some violent arrests, including an aggravated assault with a deadly weapon that is listed as a disposition with no action from 2016, and damage to property, and further FTAs, reckless drivings, unsolicited or unlicensed firearm use, theft with the firearm, and further aggravated assault with a deadly weapon with intent to kill that was abandoned in 2022, as well as an FTA. So given the circumstances in this case, Your Honor, we believe that the extra days that we're requesting, as well as a 2012 battery conviction, we believe that the extra days, as stated by the state, are more than reasonable in this case. So we would ask that the court grant the state's recommendation in this case.
Yes, Ms. Gary, I've read your expressions. If you'll give me a moment, please. Ms. Tyson, can we confirm Ms. Gary's criminal record history, please?
Yes, Your Honor. She has 1 cycle out of Georgia, no convictions, misdemeanor or felony. She has 1 juvenile arrest out of New Jersey, 19 cycles out of Florida, and also 1 arrest out of South Carolina. That was from 2010. It appears she has at least 3 FTAs out of Florida.
Does she have the firearm charge case in Florida?
Let's see.
They were in 2016 and 2019. from what I
Okay,
see,
that helps. Yes, that helps.
As well as 2022.
I see a 2016, it says resisting officer with violence. Aggravated assault with a motor vehicle with deadly weapon without intent.
And what year was that?
2016.
Okay.
Yeah. Yeah, August 2016. And it does, the disposition that's listed, it does say no action.
Okay. 2019, what happened?
Let's see. All right, we have 2019. We have a DUI, July 2019. Let's see, unlicensed. Okay, and then an unlicensed firearm, January 2020. Grand theft of firearm.
Okay. Anything in 2022?
I'm not sure what the CR is, but it says improper exhibition of weapon or firearm or dangerous weapon, carrying prohibited weapon, resisting officer without violence.
And disposition, do we have one?
Let's see, the resisting officer without violence, that one was dismissed. Let's see, and it looks like the carrying a prohibited weapon, that was also dismissed. And the improper exhibition of weapon or firearm, that one was also dismissed.
Okay. All right. Thank you, Ms. Tyson.
You're welcome.
All right, Ms. McLeod, this is a non-negotiated plea. What is the defense seeking?
The defense is seeking a time served. She's already served more than 17 days. And what the prosecution is asking for is approximately another week. And we do not think that is necessary. She is okay with the rest of the terms that are in the state's plea, including the anger management. But we feel like there's no point to asking her to spend an extra week when she could start on a rehabilitation today. She's already been in jail for approximately 20 days, I believe, or 21 days.
17 days.
Okay, 17 days. You know, that's a significant amount of time given what she's accused of doing.
Right. Thank you. Ms. Gary, I would agree with you, except that you have a significant criminal record history. You are a multi-state offender. You've got arrest cycles in New Jersey, Florida, South Carolina, and Georgia. I'm not sure whether you're trying to work your way all through 50 states, but your criminal history record and given the circumstances surrounding the incident for which we are addressing, the battery at a hotel at 355 Peachtree Street, I am completely disinclined to consider that 17 days is adequate time with regards to this charge. So I am denying the defense recommendation, and I would go with the state's recommendation of 45 days. We have given credit for 17 days, so technically she has about 7 more days to serve at the jail. She'll be placed on probation to do 4 weeks of anger management, and she'll be required to report to probation for the rest of the year and have no further contact with Alfonso Blas, and stay away from the hotel property at 355 Peachtree Street. Ms. McLeod, would your client like to consider those terms, or shall we further notice this for jail jury?
I'll ask her, Your Honor.
Okay. Do you need to call her?
Yes, Your Honor.
Okay. All right. We'll get back to Ms. Gary in a few moments. Who do we have with Mr. Dotis?
Your Honor, this is going to be position number 13, Mr. Robert Gillen. But can Ms. Cafe call her client? I chatted her the number 404-612-2392.
Okay, is that Ms. McLeod's client as well?
It is, Your Honor.
Right, we'll have to put Mr. Gillen on deck until Ms. McLeod has completed her interview with Ms. Gary.
Okay. So next we'll go to position 15, Mr. Timothy Jones.
All right. Could you get the name again? The number doesn't match the name. 18, is that correct?
Is that?
Timothy Bernard Jones?
Yes.
Okay.
Apologies, Your Honor, it is position number 18.
No problem. 23 CR 002036B is the accusation number for Timothy Jones, accused of willful obstruction of an officer, escape from confinement or custody, and criminal trespass. This is from April 1st, 2023. Mr. Jones, you've been advised of your right to remain silent, and your attorney is Mr. Dotis. We are going to address a negotiated plea. May I place you under oath?
Yes,
Do you
ma'am.
solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Ms. Duncan, what's the recommendation for all three charges? I think it's concurrent, right?
Yes, Your Honor. The state's recommendation for counts 1, 2, and 3 is 12 months to serve, 36 days. Credit for time served, 18 days with the balance suspended. Stay away from the incident location, which is the MARTA station located at 680 Lee Street Southwest, and those are to run concurrent, which is the West End MARTA.
Okay. Do you know if he's got any suspensions right now?
Yes, he was previously suspended from MARTA service. I'm not aware of the length of that suspension at this time.
Okay. Mr. Dotis, does your client accept these terms?
Yes, Your Honor, my client does accept these terms. Instead of the stay away from the MARTA station, we would ask if it could be worded just as comply with active MARTA suspensions, so that once that suspension runs its course, Mr. Jones won't be hindered in moving to and from his job.
I can modify it to stay away from all MARTA property, not just the West End property. And it would be stay away from all MARTA property, buses and trains in accordance with any active suspension.
Okay, so then I guess we'll just keep it as the stay away from that one MARTA station.
Well, if he has an active suspension, he can't use any station or any bus or train, so.
And I'm sorry to interrupt, Your Honor. I do want to clarify that this defendant does have a criminal trespass conviction from 2022 that Judge Morrow ordered him to stay away from all MARTA on December 5th, 2022, if that helps your decision.
Well, that is an active suspension right now. So he can't return to MARTA property anyways. Until what, December 6th, 2023. Mr. Dotis?
Understood, Your Honor.
Mr. Jones, you will not be able to use any of the buses, the trains. You cannot be at any of the bus stops, the train stations, the sidewalks, the parking lots until December 6th, 2023.
Understood, ma'am.
All right. And if you go back to MARTA property, you want to confirm that they don't have any suspensions against you. Otherwise, you might risk being arrested again.
Yes,
So,
ma'am.
and Mr. Dotis, do you stipulate to the factual basis, venue, and ID?
Yes, Your Honor, we do stipulate to the three elements for the purpose of this plea.
Mr. Jones, have you consumed any medication or alcohol?
No, ma'am.
And have you understood everything so far?
Yes, ma'am.
Are you satisfied with your attorney?
Yes, ma'am.
And has anyone forced you, induced you to take this plea offer today?
No, ma'am.
Has your attorney explained that if you decide to plead guilty today, that you would have to give up your constitutional right to a trial? You will not be able to confront your accuser, examine witnesses, challenge the evidence brought against you, and have the state try to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to willful obstruction of an officer, escape from custody or confinement, and criminal trespass?
Guilty.
Your sentence is 12 months to serve 36 days, credit for time served 18 days, balance suspended. As we've discussed, stay away from all MARTA property in accordance with any active suspension by MARTA and also in accordance with any prior judicial sentences, including Judge Morrow. So technically speaking, all I know is that you cannot return to MARTA until December 6th, 2023.
Yes, ma'am.
Thank you.
Thank you, Your Honor.
Okay.
All right, Ms. McLeod, are we ready with Ms. Gary?
I was trying to.
Your Honor, I still wasn't able to speak with her. I tried to get the.
I'm calling you,
over
Ms.
the jail.
McLeod. Ms. McLeod, that's me calling you.
Oh, that's you calling me? Okay.
Yes,
Okay,
I'll
thank
call
you.
you back again.
Thank you. Who do we have next to Mr. Dotis, please?
Your Honor, we have position number 25, Mr. Jarvis Mitchell. And can we settle for Miss Watson Cafe? Her client's been sitting at the phone for the past 5 minutes.
Miss Watson Cafe? Miss Zakia Watson Cafe? All right. She might.
right.
Hmm. Did my lighting just change? All right. Okay. All right, we have Jarvis Mitchell, case number 23 CR 002072G. Mr. Mitchell was accused of simple battery domestic violence from April 4th, 2023. Mr. Mitchell has been advised of your right to remain silent, and your attorney is going to be Mr. Dotis. This is going to be a negotiated plea. May I place you on oath? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Ma'am.
Thank you. You may put your hand down. Mr. Young?
Yes, Your Honor, the plea record in this case is 12 months served, 30 days credit for time served, 15 days with the balance probated, no further contact with the victim, Skylar Hickson, and stay away from 455 Cedarwood Court in South Fulton and the Family Violence Intervention Program. And I would also ask the court to sound for Ms. Hickson when appropriate, see if she's on the Zoom and wishes to address the court.
Skylar Hickson? Skylar Hickson? All right, Mr. Dotis, does your client accept these terms, and do you stipulate to the factual basis, venue, and ID?
Yes, Your Honor, we do stipulate to the 3 elements for the purposes of the plea. We would ask if there could be a one-time sheriff's escort so that Mr. Mitchell can retrieve his property from the incident location, as well as a provision for third-party transfer for the shared children, if there's no further contact with Ms. Hickson and she couldn't appear on the Zoom.
How many children do they share?
2.
Ages?
4. 4. They're both 4.
Are they twins? They're both 4?
Yes, Your Honor, my client is indicating they're twins.
Okay. Mr. Young, any objection to the one-time escort and third-party transfer?
No, Your Honor, no objection from the state.
All right. Mr. Dotis, you do stipulate factual basis when your ID, yes?
Yes, Your Honor.
Thank you. Mr. Mitchell, have you consumed any medicine or alcohol recently?
No, ma'am.
And have you understood the proceedings so far?
Yes, ma'am.
And are you satisfied with your attorney?
Say that again, ma'am.
Are you satisfied with your attorney?
Oh, yes, yes, yes.
Is anyone forcing you to take a plea offer today?
No, ma'am.
Has it been explained to you that in entering this plea, you would have to give up your right to have a trial in the future? You will not be able to have be back in a court of law in front of a judge or a jury to be able to challenge the state's evidence, examine witnesses, confront your accuser, and have the prosecution carry its burden to prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to one count of simple battery domestic violence?
Plead guilty, ma'am.
Your sentence is 12 months to serve 30 days, credit for time served 15 days. If you have no other holds at the jail, you should be released and you have to report to probation next week. While you're on probation, you have to report to probation every month. You are to have no contact with Skylar Hickson, which means you stay 200 yards away from her. You do not communicate with her in person or through a third part, except for child transfer. And you cannot communicate with her by phone or a computer device or on social media. I'm going to allow for a child, excuse me, let me touch on one other subject. You're also to stay away from 455 Cedarwood Court in South Fulton, Georgia. If you decide that you need to pick up the children and all that, you cannot do that at the house. It has to be at a location that's 200 yards away from the Cedarwood Court. Do you understand?
Yeah, ma'am.
Was that a yes or no?
I said, yes, ma'am.
Okay. While you're on probation, you'll also complete a domestic violence intervention program, and you must start those classes within 60 days of being released. Do you have personal stuff still at the Cedarwood Court?
Yes, I do. So when I get out, I need the yes, sir. I'm in here, ma'am.
Okay. I'll allow you a one-time escort, which means that you got to have a police officer escort you for a one-time visit. So I don't know how much stuff you have, but you need one car, a van, or a U-Haul, you have to make those arrangements.
Okay.
And when you go there, your visit cannot exceed 2 hours. And that 2 hours is only to retrieve your personal property, not to sit down and have a cup of tea. You understand?
Yes, ma'am.
And while you are there, if there is any item that is in dispute, in other words, if Ms. Hickson says that's my stuff and not yours, you got to leave it behind. You cannot argue about the possession of an item on this one-time visit.
Yes, ma'am.
There cannot be any breach of peace. If there's even one dispute, the officer is authorized to stop that visit and you leave with what you have.
Yeah, ma'am. I agree to that.
Now, third-party transfer of children. Were you married when the children were born?
No, we're not.
Have you filed a legitimation action?
No.
All right. If Ms. Hickson says that she doesn't want you to see the children, then you need to file a legitimation action and get a court order in order to get partial custody and visitation, okay? But if she agrees that you can see the children, then you got to see the children through a third party, not Ms. Hickson. That third party needs to arrange for pickup and drop off. Understood?
Yeah, ma'am.
All right. Thank you.
Okay, thank you.
And Your Honor, my apologies for not bringing it up earlier, but is there any chance this court could cut Mr. Mitchell a break on his probation fees and waive 2 or 3 months to help him get back on his feet?
I'll wait 3 months, so it'll be April, May, and June.
Thank you, Your Honor.
But he needs to be enrolled within 60 days, so.
Understood, Your Honor, and I've provided him with probation's contact sheet, so that shouldn't be an issue.
Okay, thank you. Ms. McLeod, are we ready? Will Ms. Gary and then the next one, Mr. Gillen?
Yes, Your Honor, we are.
Okay, thank you. Going back to Ms. Gary, the position number, was it 12? No. Yeah, position 12. Ms. McLeod, case 23 CR 0020308. How is your client going to proceed?
She wants to plead to the charge, Your Honor.
And she will accept that she has to be on probation for the next year?
Well, Your Honor, that was the issue. She was under the impression, and so was I, and Mr. Howard as well, that the probation was going to be suspended once she completed the 4 weeks of anger management.
I only have the offer that is made today. I don't know of any other offer. So if the state was willing to go back to a prior arrangement, that's entirely up to the state. But who was it? Ms. Duncan? Is this the offer that's today?
The offer before the court today is the offer, and it's my understanding that we were not in agreement about probation terminating.
Okay. So Ms. Gary, if you decide to plead guilty today, you'll have to stay in jail for 7 more days. And then you have to be on probation for the next 11 months, 11 and a half months. 10 and a half months. Do you want to accept this plea offer, or would you like to plead not guilty and go to trial?
Yeah, I'm accepting the offer.
Ms. McLeod, shall I proceed?
Yes, Your Honor. And I would ask the court if the court would consider waiving some of the probation fees for her because she's currently unemployed. She was unemployed at the time of the incident.
No, I was employed, but I'm sitting in jail, so now I'm unemployed.
Right.
I will waive her probation fees for April, May, and June, but she will need to start paying probation fees from July 1st onwards.
Thank you,
So,
Your Honor.
Ms. McLeod, shall I proceed?
Yes, Your Honor.
Ms. Gary, please raise your right hand. Do you solemnly swear and affirm? You solemnly swear and affirm the testimony you provide will be the truth?
Is this the right hand?
Do you swear the testimony you provide will be the truth?
Yes.
Thank you. Ms. McLeod, you stipulate to the factual basis, venue, and ID?
Yes, Your Honor.
Ms. Gary, have you consumed any medication or alcohol recently?
No.
And have you understood the proceedings so far?
Yes.
Are you satisfied with your attorney?
Yes.
And is anyone forcing you or inducing you to take this plea offer today?
No.
If you decide to take this plea offer, you would have to give up your right to have a trial. You will not be going back to court with your attorney. You will not be able to challenge the evidence brought against you, to confront your accuser, examine witnesses, present any defenses if you choose to do so, and have the state try to prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes.
How do you plead to one count of battery from April 2nd, 2023? Ms. Gary, how do you plead to the one count of battery?
Guilty.
Repeat. Repeat your response.
Oh, guilty.
Your sentence is 12 months to serve 45 days, credit for time served 17 days. You'll be placed on probation. Once you are released, you'll need to report to probation. While on active probation, you are to stay away from 355 Peachtree Street in Atlanta, Georgia. You have to stay 200 yards away from that property location. You're also to have no contact with Alfonso Glass, who is the alleged victim in this case. You're not to communicate with him in person, through a cell phone, computer, or on social media. While you're on active probation, you will complete 4 weeks of anger management classes. As I'm waiving your probation fees for April, May, and June, I'm waiving your probation fees for the first 3 months. You will begin the anger management classes within 60 days of being released from jail. No alcohol, no illegal drugs, no weapons, and no firearms. Any questions, Ms. Gary?
No.
Thank you. Best of luck. All right. This is courtroom 2. Do we have Mr. Robert Gillen?
Well, yeah, I can swap them out. I'll go after.
This is State versus Robert Gillen, 23 CR 002031G, accused of simple battery and criminal trespass from April 1st, 2023. Mr. Gillen, you've been advised of your right to remain silent, and your attorney is going to be Ms. Maureen McLeod. Position number 13, Ms. McLeod, how are we proceeding?
It's a negotiated plea, Your Honor.
All right, Mr. Gillen, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, Your Honor.
Thank you. Ms. Duncan, what's the plea offer?
Yes, the plea offer in this case for counts 1 and 2 is 12 months served, 36 days. Credit for time served, 18 days, with the balance probated. No further contact in this case with Sebastian Kicklighter. Stay away from the incident location, which is the 9955 Old Dogwood Road, and 4 weeks of anger management.
Ms. McLeod, does your client accept these terms and do you stipulate to the factual basis, venue, and ID?
Yes, I do, Your Honor, but there is one issue. My
Yes.
client he was on his way to rehab at the time this incident happened, and he still is going to go to rehab. So I wanted to ask the court if any probation could start after all that is done, because he has to go to rehab.
And is this going to be an inpatient process?
Yes, Your Honor.
I'll allow for probation to be suspended temporarily while he shows proof that he is an inpatient at any rehabilitation facility. He would need to show his intake date and then report back to probation once he's discharged. The probation will be told pending his time in the rehabilitation facility.
Thank you, Your Honor.
All right, Mr. Gillen, did you understand that explanation?
Yes, Your Honor.
That means that your probation is not going to be cut short when you are in the inpatient facility. You must report to probation, and then once you have a set date of when you're going to be entering the facility and when your probation will be told. In other words, it'll just be in temporary suspension. It'll be on hold.
I talked to the counselor. He said that I can have days to go report. I can still report while I'm on rehab.
No, you have to report in person. So if you're going to be reporting in person.
There's only a 2 week, there's only a 2 weeks, a blackout period for 2 weeks.
All right, like I said, probation will know about that. And then when you go in, if you want to continue reporting, that's fine. But probation will be told while you are in the facility.
Okay.
All right.
Yes, Your Honor.
Okay. Is that satisfactory, Ms. McLeod?
Yes, Your Honor.
Mr. Gillen, have you consumed any medicine or alcohol recently?
No, Your Honor.
And have you understood the proceedings so far?
Yes, Your Honor.
And has anyone forced you or induced you to take this plea today?
No, Your Honor.
Are you satisfied with your attorney?
Yes, Your Honor.
And if you decide to enter a plea to this 2 charges, you would have to give up your right to go back to court and have a trial. There won't be an opportunity to have a counsel assist you to confront your accuser, examine witnesses, challenge the evidence brought against you, and have the state carry its burden to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, Your Honor.
How do you plead to 1 count of simple battery and 1 count of criminal trespass?
Guilty.
Your sentence will be concurrent, 12 months to serve 36 days, credit for time served, 18 days. So that should conclude your jail time if you have no other holds. Yes?
When I complete the anger management courses, does my probation end when I complete it?
No. Do you still want to continue?
Yes, Your Honor.
Once you've completed the jail time, you will be released within 24 hours. If you have no other holds, then you have to report to probation. While you're on probation, you will report every month, except for the time that you will be an inpatient at a rehabilitation facility. And during that time, your probation will be told or suspended temporarily. Your probation will resume once you are discharged from the facility, and you must report within 72 hours of being discharged. Do you understand?
Yes, Your Honor.
At all times, you are to stay away from 9955 Old Dogwood Road in Atlanta, Georgia, and have no contact with Sebastian Kicklighter. While you're on probation, either before you start your rehab or after you start your rehab, you must complete 4 weeks of anger management classes.
Yes.
Understood?
Yes, Your Honor.
Thank you.
And Your Honor, that location is Studio 6.
Is that a motel?
Either a motel or a club, I'm not sure.
It's a hotel of sorts, Your Honor.
Okay. All right. Thank you, Mr. Gillen.
Thank you, Your Honor.
Thank you, Your Honor.
All right, Ms. McLeod, I think you have one other case, right? So
I
we'll,
do, Your Honor.
all right. Who do we have, please, in courtroom 2?
Next, Your Honor, we have position number 27, Mr. Sagos.
We have Mr. Pinckney also. Is he going to be there by any chance?
He's here, Your Honor. I'm just going by floors. I'm gonna get to him as soon as possible.
Okay. 27 is, we just finished Wen and Parker, didn't we?
No, this is position, oh, I'm sorry, 37, Sagos. Oh, man.
37.
I'm not
Okay.
on my game today.
Give you a few more moments. Okay. All right. This is position 37, case 23 CR 0005428, State versus Antoine Sagos, represented by Mr. McLean. Mr. Sagos has been advised of his right to remain silent. He's been accused of battery, domestic violence from November 30th, 2022. And this is going to be a arraignment.
Correct, Your Honor. It turns out this is not holding him in jail. This matter is not on his booking frame. He wishes to plead not guilty. We waive formal reading of the accusation, and we ask the court to arraign him by telling him about future court dates and such.
Mr. Sagos, you've been accused of this misdemeanor offense of battery, domestic violence on November 30th, 2022. You are legally presumed innocent of this charge, and upon your entry of a not guilty plea, the case will be scheduled for trial. At the time of the trial, the prosecutor has the complete burden to prove the charge against you beyond a reasonable doubt. If the state prevails and overcomes your legal presumption of innocence, you could be found guilty and be sentenced to up to a year in prison and or up to $1,000 fine. Given this information, how do you plead?
I plead not guilty, ma'am.
Your case has been arraigned and it's going to be further notice to jail jury. Since this case is not holding you at the jail, it's possible that whichever hold, I don't know, Mr. McLean, is he going to be picked up by another jurisdiction?
No, Your Honor. Oddly enough, it was a strange circumstance. There's a accusation that was from November the 6th of that year, in which he was accused of cutting off electric power as a mean thing to do. So
Is that in Superior Court?
no, that's also in this court, but it'll have to come around somehow to
What's that case number?
it is, if I might scoot over here for a sec.
Casey, do you know if he has another case? Repeat?
Oh, Michael was asking.
Oh.
Let's see if I can find the booking screen that will have that. I believe that is 23 CR 001794, and then the rest of it's cut off. He also, Your Honor, is here for a probation violation accusation of a 15 SC case of theft by receiving and tool. Although it's a felony, just looking at the charges, he may not be in that much trouble on that. But the CR case, other than ours, he says that that's been taken care of, although it's still showing on his booking screen.
Okay, well, I can't address the SC cases as those are felony matters, but let's see, 1794A.
Right, it's a theft by receiving of items out of a truck and
Okay,
cutting off the power on November the 6th of that same year.
all right. He's filed a waiver of arraignment in the other charge of theft by taking criminal trespass. And that case is scheduled before Judge Roth for a status conference on May 9th, 2023.
Excellent.
Whoever's the solicitor there, they might want to address both cases at that status conference.
I would agree.
And Your Honor, I'll make sure our office notes that there are two cases and that they need to move together and an offer needs to be conveyed to resolve both.
All right, sounds good. Thank you, Mr. Sagos.
Thank you, Your Honor.
Yes, ma'am.
All right, next case, please.
Next, Your Honor, is going to be position number 28. Mr. Pinckney.
All right, thank you. This is Curtis Pinckney, 23 CR 0020448Y, accused of criminal trespass and causing damage to property. Ms. Pinckney, you've been advised of your right to remain silent, and your attorney is Ms. McLeod. And this is going to be a negotiated plea, non-negotiated.
Non-negotiated, Your Honor.
Is it 28? I'm sorry, negotiated?
Non-negotiated, Your Honor.
Non-negotiated, okay. So, Mr. Pinckney, I'm going to hear what's the plea recommendation from the state, and then I'll hear it from your attorney. I'll let you know which recommendation I'll accept, keeping in mind that I also have the discretion to refuse either recommendation and have the case scheduled for trial. Mr. Young, what's the state's recommendation?
Your Honor, the state's recommendation in this case is 12 months, 30 days in jail, credit for time served, 15 days to balance probated, to stay away from 2900 Camp Creek Parkway, apartment M12, no further contact with Braxton Willens, and restitution to be held open for 30 days with a 4 weeks anger management. That's the state's offer in this case.
All right. I will hold the restitution open with probation. In other words, probation has, the state has 30 days to submit the evidence of their restitution to probation, but I need to know a maximum value. Because I'm not going to sentence him and then you'll come up with a $5,000 restitution. What are we talking about over here?
We would absolutely stipulate to the statutory maximum and not expect
statutory maximum for restitution?
No, what I'm saying is,
what section is that? I've never heard of that.
What you just alluded to was the state asking for restitution on a felony level after a case has been sent or sentenced. We would never do that. We're absolutely going to say this is a misdemeanor case, and if you should sentence it, we wouldn't try to jump in and change the restitution amount later to felony amount.
What is the restitution amount in this case? What's the item that was damaged?
The item that was damaged was a door.
What kind of door?
It was a door to the residence, the front door of the residence.
The apartment at 2900 Camp Creek Parkway?
Yes, Your Honor.
All right. All right, so Mr. McLeod, what are you seeking?
Your Honor, the biggest issue for us was the probation. My client has to go to Clayton County, and he's going to be on probation in Clayton County, and he just will find handling 2 probations to be a burden for him. My client has a child who's just about to turn 2 years old. He also is expecting another child in June. So he has these family obligations, and as stated, there's a hold for Clayton County, and he's already negotiated where he's going to have probation for that. So he just doesn't want to have 2 probations. So we were hoping that any probation could be suspended after he completes the anger management course. Otherwise, we're in complete agreement with the recommendation of the state. Of course, we would also like a specific amount of the restitution.
And what do you anticipate a door repair in this case would be?
Maybe $200 or $300.
Less, because we are all such avid Home Depot shoppers, right?
Well, I go there from time to time.
I see. Okay.
So
the accusation says that the damage was no more than $500. So it's going to be no more than $500 upon proof of receipt as to the actual funds paid to repair the door. And that's the best I can do. That's the best Solomon I can do right now. Okay.
And Your Honor, I have a question about, I guess, misdemeanor probation. So if this gentleman has a pending matter in Clayton County that is a probation issue and is pleading guilty to a Fulton County issue, doesn't probation usually happen in the county in which you live? So if you let probation know you live in a different county, you can ask for it to be transferred to that county. It's not typical, in my understanding, to be on probation in multiple counties.
You see, in these kind of circumstances, I take the very prudent route and summon Miss Thomas from JCS. So today I have Miss Lewis. Miss Lewis, good morning.
Good morning.
And the question is, if Mr. Pinckney has probation in, what was it, Carroll County? Clayton County. If he has an active probation in Clayton County, is it possible for Fulton to transfer the Fulton probation to Clayton County so that he needs only do one probation to satisfy both?
Yes, he can do that just as long as it's in the paperwork.
All right. And does he need to show proof that he lives in Clayton County?
Yes, ma'am.
All right. And Ms. McLeod, would that work? Does he live in Clayton County?
Good morning, Your Honor. He lived in Fulton County, but we can ask him. Mr. Pinckney, where do you live?
I stay in East Point.
So you live in Fulton County?
All right. Ms. Trina Harris, what is your?
Yes, good morning, Your Honor. When it comes to our department, we do not transfer cases to other county. It has to stick with Fulton County.
All right. Well, that's a conflicting viewpoint there. Okay.
And so I guess the question is for probation who just chimed in, if he has active probation in Clayton County as well, but lives in Fulton County, how does that get addressed? Is it expected that he goes back and forth to report to both counties?
Yes.
Yes.
You don't have to get permission to travel?
No, Miss Allen, seriously, this is a very interesting discourse on probation issues. But if y'all want to discuss that and figure it out outside of SAP, I'll be glad to do that. But right now, I'm not inclined to suspend his probation in Fulton County for this case. He's had a prior case, 22 CR 001338Y. So this is not Mr. Pinckney's only issue in Fulton County. So 1338Y. He has a warrant hold in this very same case? Oh, he has a warrant in that other case I just read off also.
Yes, Your Honor.
Yeah. Oh, you're here for Mr. Pinckney, yes. Yeah, there's a young lady in the courtroom for Mr. Pinckney also. Yeah. So he hasn't even signed up for Clayton County probation either. So,
not yet.
Yeah.
The plan was
So
to do so.
Ms. McLeod, you might want to ferret more information from Mr. Pinckney. His mom is in the courtroom, and Ms. Allen, y'all can discuss this. But right now, if he lives in Fulton County, he must report to Fulton County probation. If Clayton County is willing to transfer their probation to Fulton County, I don't see, then they're perfectly free to do that. But if they don't transfer, then he has to report to two places. But presently, he's got another little wrinkle in this big fold, and that is that he's got a warrant in 22 CR 001338Y.
Well, Your Honor, we were hoping that the court would reinstate his bond in that case, Your Honor, since he's actually here. We can't hear you.
The arrest warrant was issued on September 3rd, 2022. He's got a bond, a cash bond only.
He's not in a position to pay that bond, Your Honor.
And a 5A has already been issued on the bond forfeiture. So I'm not certain what I can set aside at the present time since he's already under arrest and the arrest warrant has been executed. All right, I'm going to allow the, yes, ma'am, if you have to stand up, come up to the podium. Mr. Pinckney's mother is in the courtroom. Yes, ma'am.
How you doing?
Fine. Do you solemnly swear the information you provide will be the truth to the best of your knowledge?
Yes,
Your name, please?
Alicia Glass.
Alicia West,
Glass, GLASS.
GOSS. GLASS.
LASS, Your Honor.
All right, good. All right. And Ms. Glass, what would you like to tell us?
What was the warrant for in September?
Failure to appear.
For which court?
This court, Fulton County State Court. He's got another open case.
Okay. Do you know the charge for that?
1338Y. He's charged with simple battery, domestic violence from December 27, 2021. He was in jail on March 12, 2022, and he received a bond, a $5,000 good bond from Judge Mincy.
Okay. I don't know if he was aware that he was supposed to be in court.
Well, as long as he maintains a good address with the court, notice was sent and he did not appear. He did not appear before Judge Edie on August 31st, 2022, and the arrest warrant was issued on September 3rd, 2022.
I know that during that time, he was homeless, pretty much, kind of bouncing from place to place. He had just recently got the apartment in East Point in April 1st.
Okay.
Prior to that, a year prior, he had bounced around, so I'm pretty sure he wasn't aware of that court date.
Understood. Anything else?
That's it.
Thank you. Ms. McLeod, anything else? Do you still want to proceed with this plea?
No, Your Honor, at this point, he's not going to get out of jail, so I don't think it's a good idea for him to go ahead with the plea unless we can find out what is going to happen with this other case.
I will reset both cases to next Tuesday, and that would be for 23 CR 002-048Y and 22 CR 001-338Y. And it would be best if, Ms. McLeod, if there is some effort to reach out to Clayton County to see how probation may be addressed at that time. Because if he accepts a plea offer and if probation is on the table again, he will need to report to Fulton County probation. And it would be best if he addressed both cases.
Yes, Your Honor, I agree.
Thank you. Thank you, ma'am. Mr. Pinckney, we'll see you next Tuesday at 9 o'clock. Your attorney is Ms. McLeod. Do you see her on the screen?
Yeah, ma'am.
All right. You need to be very forthright with her about what's going on with you. Thank you.
You can give me a call later. You have my number, correct?
Yes, Ms. Goss, what can I help you with?
Information.
All right, if you step back to that, because Ms. Glass, what's your phone number? 470-263-4077. 4077. Ms. McLeod, shall I repeat the number?
Yes, Your Honor.
470-263-4077, Alicia Glass. And that's the mother. If you'd be kind enough to respond to her, then
I will, Your Honor.
She'll try to keep you also on the same page. Thank you. Position number 28 is reset along with the other companion case to, oh dear, in 425. Thank you.
Next is position 1 and 2. Mr. Allison.
All right, this is Shakari, help me.
Shakari Allison.
Shakari Allison. Position 1 is 17 CR 17310173116Y. Second case is a bench warrant 23 FTA 301. Ms. Duncan, do you agree to set aside the bench warrant and vacate it?
Well, Your Honor, in this case, as I notified the defense counsel, the proof of incarceration that was provided to the state only covers the 2023 FTA. This defendant also failed to appear in 2017.
This 23 FTA 301 is for what time frame? What date did he not appear?
So the proof of incarceration that I received would cover the 2023 FTA. However, when I was doing my research on the case, I did see that this defendant has failed to appear twice. So we would defer to the court on that.
Okay. The bench warrant set 23 FTA 000301 is vacated and set aside. All right. Mr. Allison, you've been advised of your right to remain silent. Your attorney is going to be Mr. McLean. And Mr. McLean, this is going to be a waiver of arraignment. Will you be filing a waiver?
This will be my case. Actually.
Oh, I'm sorry, Mr. Dotis.
That's okay. McLean was trying to steal my thunder.
Oh.
For position one, yes, Your Honor, we'll be waiving arraignment and entering a plea of not guilty. For position two, just to clarify, is that going to be no prost, or would you like me to send paperwork to set aside?
So you will send two documents. Position number one, you're sending a waiver of arraignment, and that's going to be further notice to jail jury. Position number two, you're going to send a proposed order based on proof of incarceration. The bench warrant issued in the FTA case is vacated and set aside.
Thank you, Your Honor. And my understanding is, I know Ms. Duncan brought up a past 2017 FTA, but my understanding is that that has already been dealt with and he was given a bond. The only thing holding him right now is this February 23rd, 2023 FTA, which once we resolve, nothing else should hold him. So that's my
If you believe that there is an outstanding warrant in the 2017 case, I'll be glad to set it aside also, because this was a warrant. Hang on, this is a warrant from Judge Edie for failure to appear on February 23rd, 2023. That was the proof of incarceration, right?
Yes, Your Honor.
Okay, so in the 17 CR 017316Y, please also provide a proposed order. That way, all these outstanding warrants.
It's the same.
Oh, it's the same case? Oh, it's the same case. Okay, well, I'm like rattling you off for both same cases, so. All right, go back to my first one, two orders. The waiver of arraignment and the set aside the bench warrant.
And just to be clear, Your Honor, as well, this defendant does have an open Superior Court case. And it's 22 CP 214588. And that's possession of a firearm by convicted felon and failure to obey stop sign. And I did see that this defendant has a probation violation out of Covington, Georgia hold as well.
Your Honor,
No, wait. Hold. Sorry. In the CP case, is there a bench warrant?
I can check for Your Honor. I just saw that it was open. One moment.
If there's no bench warrant and if there's no probation hold, then he can, that he only has this 17 CR, the waiver of arraignment, and his further notice. Just make sure his address and contact information are current with the court.
Correct, Honor. I've verified that address. And again, I don't think it's necessary, as Your Honor stated, to get into those other cases, because the only thing holding him is this FTA that's about to be set aside.
Okay. All right, Ms. Duncan, any hold?
I'm checking, Your Honor. No, they're both open. It currently just has a petition or motion for bond from 2022.
Okay. Well, he needs to speak to his PD or his defense counsel for the Superior Court case, just to make sure no warrants issued.
Thank you, Your Honor. I'll pass that along.
Thank you. Okay. Deputy, next case, please.
Position 34, Ms. Raglan.
Willie Bass?
34, Raglan.
Oh, 34, excuse me. 34. This is Nikki Raglan, accused in two separate cases. The first one is position 33, 22 CR 008-282A. Ms. Raglan was accused of reckless driving from August 23rd, 2021. And there was also a bench warrant issued on February 14, 2023, 23 FTA 298. I understand, Ms. Raglan, that you have a right to remain silent as you've been advised, and your attorney is Mr. Howard. Mr. Howard, you okay. I'm just, you keep bouncing around, so just want to be sure he shows up there. All right. So Mr. Howard is going to represent you. This is going to be a negotiated plea. And the state is going, sorry, Ms. Raglan, may I place you under oath? Do you solemnly swear the information you provide will be the truth?
Yes, ma'am.
Thank you. Mr. Young, yes, sir. What's the plea recommendation for the reckless driving?
Yes, Your Honor. The plea recommendation for the reckless driving is 12 months served, 30 days credit for time served, 16 days credit from 12/4/22 to 12/29/22. A $500 fine and a driving improvement course approved by the Department of Driver Safety. And if she pled, we would no price, position 34, the FTA.
All right. Can I terminate probation upon completion of the fine and defensive driving?
State has no objection.
Mr. Howard, does your client accept these terms and do you stipulate to the factual basis, venue, and ID?
You do stipulate to factual basis, venue, and ID. The only, I guess, deviation from the offer is that the $500 fine, we're asking that be converted to 50 hours of community service. As Ms. Raglan is disabled actually as a result of the accident.
All right. I will waive her probation fees for April, for June, and need to get back to the present, to April and May. And once she's done with the defensive driving class and the 50 hours community service, and probation will terminate. Would that be acceptable?
Yes, Judge, and we're also asking that this be entered as a nolo contingent plea as opposed to guilty.
All right, I'll accept a nolo contendere plea as long as she's not pled in the last 5 years since August 23rd. Because DDS will automatically convert it to a guilty plea. Okay?
Okay, thank you, Judge.
All right, Ms. Raglan, have you consumed any medication or alcohol recently? You need to say yes or no.
No, ma'am.
And have you understood the proceedings so far?
Yes, ma'am.
Are you satisfied with your attorney?
Yes, ma'am.
And has anyone forced you or induced you to take this plea?
No, ma'am.
By entering a plea of nolo contendere to the charge of reckless driving, you will have to give up your right to a trial in front of a judge or a jury. You won't have the assistance of counsel to challenge the state's evidence, present your own defenses, examine witnesses, confront your accuser, and have the state try to prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to one count of reckless driving?
Nolo.
Say it with conviction.
Oh.
Say it like it means.
Oh, Nolo.
12 months probation, 12 months to serve 30 days, credit for time served 16 days. The remainder of the time will be on probation. I will waive your probation fees for April and May. You will need to complete 50 hours of voluntary community service and complete a defensive driving course at your expense. If you complete both of these before the end of May, your probation will terminate. Thank you.
Thank you, Judge.
Thank you.
Position 7.
Mr.
Character.
Position 7 is located at 4 North. This is Gerard Character, 23 CR 002-079G. Mr. Character, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you is going to be Mr. Dotis. Okay. This is going to be a not guilty plea. Mr. Dotis, are you planning to submit a waiver of arraignment?
Yes, Your Honor, and I'll have that submitted as soon as I leave the courtroom.
All right. And Mr. Dotis is seeking a modification of his bond as well. So you may proceed, Mr. Dotis.
Yes, Your Honor. Do we want to hear from pretrial or Ms. Duncan?
All right. Ms. Tyson, may I have the GCIC for Gerard Character, position 7?
Yes, Your Honor. Defendant has 2 cycles, no misdemeanor or felony convictions listed.
All right. And Mr. Dotis?
Yes, Your Honor. Mr. Character is 23 years old. He's currently held on a $10,000 surety bond, which has held him in the Fulton County Jail for 15 days that he's been unable to pay for. For these reasons, we would request a signature bond so that Mr. Character can get out and be a part of his defense as he maintains his innocence in these accusations. I spoke with his cousin, Mr. Carell Adams. Mr. Adams is helping me contact more of the family. Mr. Character was unable to provide any more phone numbers, but we are working on that to see if there's any way that we can help him be released. Mr. Character is a lifelong resident of the state of Georgia and the city of Atlanta. I do have a stable address in the city of Atlanta, so I don't believe he's a flight risk. And again, he does have family, according to Mr. Adams. He's a high school graduate from Charles Dredd Charter School, and he attended college at Kennesaw State University. And he wants to continue at Kennesaw as he tries to get a degree in software engineering. He's also currently employed with United Pools, which he believes he can return to as long as it doesn't continue holding him. As we heard from pre-trial, he only has 2 cycles and no prior convictions. And we welcome any other circumstances this judge or this court would find to ensure the safety of the community while not hampering Mr. Character's freedom.
Has the state submitted this case to the district attorney's office?
I'm checking, Your Honor, just briefly, one moment. I beg the court's indulgence. This case currently has not been sent to the district attorney's office. In this case, he received a $10,000 surety given the nature of the charges alleged, and from what I gathered in my research, I did see that other arrests as a theft by taking and financial transaction card theft as a conviction. In this case, as Your Honor knows, the state has a huge concern about the safety of the citizens of Fulton County given the rise in gun violence, and in this case, a firearm is alleged to have been present in this instance. He went into that location at 1411 Venetian Drive Southwest and admitted to, after being Mirandized by officers, getting into a verbal altercation with the store clerk or owner at that time. And that firearm that he had with an extended magazine was visible to that victim at that time. His name was Mr. Nehemiah. That's in
Mr. Nehemiah does. Yeah, I've read the warrant.
Yes, I understand, Your Honor. Just for the record, I just wanted to make sure that Your Honor understands the severity of this situation. He admits to arguing and threatening this particular defendant, and with that weapon, that extended magazine, we have some extreme concerns about the risk of offense and the danger to this particular victim and the citizens of Fulton County, given the rise in gun violence. We take irresponsible and or reckless gun ownership and possession very seriously. So at this time, we do not believe that, we believe that that $10,000 surety is more than reasonable in this case. The state's recommendation would have been 12 months to serve, given that there is a gun involved, and we're continuing to move forward with this case. So that's all from the state.
Oh, all right. Yes, Mr. Doris, you have the last word.
Yes, Your Honor, we understand what's in the probable cause affidavit. Again, Mr. Character maintains his innocence. I haven't seen any video footage, nor have I seen the actual statements from Mr. Nehemiah. It doesn't seem like the officer spoke with Mr. Character, and I don't see anything in the probable cause saying that he saw the gun, so we only have Mr. Nehemiah's testimony. So we would, request this bond reconsideration, and Mr. Character would be clear that the conditions would include no alcohol, drugs, or weapons, a stay away, and no further contact, and that if there were any further violations or any potential safety concerns, that that bond would be revoked.
And it was captured on video surveillance.
All right. So I don't know what was the, I'm just reading the warrant. My first question was, if there is evidence of third-party corroboration, why hasn't this case been presented to the district attorney's office? So that's my first thought, but it hasn't been. It's been at least 2 weeks since the incident date. So I'm not certain of the delay.
Your Honor, there are certain cases we know not to present to the district attorney's office because they will not take them.
Okay, well, that's the ASG's decision. But in the meantime, this is a allegation of disorderly conduct as opposed to terroristic threats, and a gun was involved. Though reading the warrant, I'm not certain if the gun was removed from the defendant's pocket. Bond is going to be set at $3,500. It's going to be a surety bond. And this is based on the defendant's minimal criminal history record, as well as the fact that based on the allegations set forth in the warrant, but that's all we have.
Okay, thank you, Your Honor. I'll prepare that.
No, I'm not done, Mr. Dotis. I'm not done. You know, I'm in my lecture mode right now, so give me a few moments, all right? Mr. Character, I agree with the ASG Duncan that we do have a great concern about individuals who have a right to own firearms, but we have greater concern about individuals who are allegedly irresponsible and completely stupid when it comes to handling those firearms. And you fit both categories. So right now it is a surety bond. You are not allowed to own a firearm. You're not allowed to own any firearms. You are required to surrender all firearms to the authorities for destruction. From this point onwards, if you are caught and you are in possession of a firearm, your bond will be revoked, and instead of being 10,000, it'll just be a simple 0. Do you understand? You are to stay 500 yards, not 200, but 500 yards away from Mr. Nimai Das. In case you're curious, 100 yards is, I'm told, the length of a football field. So just multiply that by 5. You're a software engineer. I'm sure you can come up with that, right? Okay. You are also to stay 500 yards away from 1411 Venetian Drive in Southwest Atlanta. You're not to be anywhere near that location. So you have to keep at least 2 miles away from that location, from Mr. Das, and make sure you surrender all firearms for destruction. And Mr. Dotis, you're submitting a waiver of arraignment, so this is going to be further notice jail jury. So 2 documents for this case as well, Mr. Dotis.
Thank you, Your Honor. I'll submit this.
Ms. Strong is keeping track, so you know, it's up to you.
I know, Your Honor. You don't have to tell me twice.
All right, thank you. All right, thank you. Next case, please.
Position 3 and 4, Bass.
Casey, this is Ms. Raglan. 3 and 4. Willie Bass is 20 CR 001753E, accused of disorderly conduct and simple assault. And Mr. Bass also has a bench warrant 23 FTA 303 issued on October 13th, 2022. Mr. Bass, you have been advised of your right to remain silent, and your attorney is going to be Mr. Dotis. May I place you on oath for this plea? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
I do.
Thank you. And Mr. Ms. Duncan, what's the plea recommendation for position 3?
Yes, Your Honor. In this case, the state's recommendation for counts 1 and 2 is 12 months to serve, 24 days, credit for time served, 12 days with the balance probated, 2 weeks of anger management, no alcohol, drugs, no further contact with Patrick Montooth, and to stay away from the College Park MARTA station.
Right. Mr. Dotis, is that the, are these the terms to which your client has agreed, and do you stipulate factual basis, venue, and ID?
Yes, Your Honor, we do stipulate to the 3 elements for the purpose of the plea. Our only diversion would be, instead of stay away College Park MARTA, if we could just word it as comply with all active MARTA suspensions, so that once any active suspension, then Mr. Bass isn't kept away from getting to and from work and navigating.
I agree. Anything else?
Nothing further, Your Honor. If I
right.
stated that I stipulated the 3 elements, but just in case, we do so stipulate.
Okay. Mr. Bass, have you consumed any medication or alcohol recently?
No, Your Honor.
And have you understood the proceedings?
Yes, Your Honor.
If you decide, excuse me, is anyone forcing you to take this plea?
No, Your Honor.
And are you satisfied with your attorney's representation?
Yes, Your Honor.
If you decide to take this plea, you would have to give up your right to a trial. There won't be an opportunity to confront your accuser, challenge the state's evidence, present your own defenses, and have the state carry its burden to prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, Your Honor.
How do you plead to disorderly conduct and simple assault?
Guilty, Your Honor.
Your bench warrant case is going to be null pros. In other words, it's going to be closed out. On your sentence for the disorderly conduct and simple assault is 12 months to serve 24 days, credit for time served 12 days. If you have no other holds at the jail, you'll be released on probation. You have to report to probation next week, and while on probation, you need to complete 2 anger management classes and have no contact with Patrick Montu. You're also to stay away from all Marta property in accordance with any active suspension you may have. Your probation may be non-reporting once you complete the anger management classes. Thank you.
And Your Honor, Mr. Bass does indicate that he'll have issues with finding a job upon release. If possible, we'd ask this court to cut Mr. Bass a break by waiving a few months of probation.
I will waive it for April and May.
Thank you, Your Honor.
Excuse me, Your Honor. I have position 19 and 20, Mr. Kendall, but I believe he needs to talk to Mr. Otis.
Mr. McLean? Is that 29 and 30?
No, 19 and 20.
19 and 20, excuse me. Is that Mr. Dotis or Mr. McLean?
Dotis.
Yes, Your Honor, that'll be my client if I could be placed in a quick breakout room.
All right. Let's see.
Or if we want to come back, but I have some more clients in the room, I know.
All right. Mr. McLean, do you have any clients in courtroom 2 that need to be addressed?
Yes.
Okay, after I do this case, then we'll address Mr. McLean's cases. And then Mr. Dotis, you will have your laptop and in a secure area where you can do a breakout with 4 North, okay?
Thank you, Your Honor.
All right, so who do we have right now seated next to you? 1 minute, Ms. McLeod.
This is position 5 and 6.
Okay, thank you. Yes, Ms. McLeod?
Yes, Your Honor. I represent Mr. Kendall, and I haven't had a chance to speak with him yet.
Oh, you represent Mr. Kendall?
Yes, yes.
Okay, well, that makes it easier then. Mr. Jordan, the host, could you please place Ms. Attorney Maureen McLeod in 4 North in a breakout, please? Ms. Akia,
Okay,
Watson
Jen.
Cafe? Yes, please hold. We're going to address Mr. Poe very shortly. Thank you. We had called you earlier, sorry. All right. Quazion Bethea is 22 CR 005668F. And Mr. Bethea has a bench warrant also in 23 FTA 302. In position 5, Mr. Bethea is accused of hindering a person from making an emergency phone call and theft by taking. Mr. Bethea, you've been advised of your right to remain silent, and your attorney is Mr. Dotis. What are we doing on positions 5 and 6? Is this, what are we doing?
Position 5 is going to be a negotiated plea after further discussion with the state, and we would request for Mr. Bethea to enter a plea of no contender.
All right, and Ms. Duncan, is the state have any objection for a novel contendere plea for position 5? And will you null pros if the plea goes forward for the bench warrant?
Yes.
This case has been negotiated, so at this time, the state does not have any objection to nolo, and I would assume that Ms. Allen, we don't have any objection to the no pros in position 6 if this defendant pleads nolo in contradiction to the guilty that we had requested.
All right, thank you. All right, Mr. Bethea, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. Ms. Duncan, for counts 1 and 2, doesn't look like it is concurrent, but a couple of different conditions. What are they?
For this case, Your Honor, for count one, the state's recommendation is 12 months to serve 15 days. Credit for time served 2 days with the balance probated, 2 anger management courses, no further contact with Zachary Curtis, that's Zachary, Curtis, common spelling, no alcohol, drugs, and weapons. And for position 2, the state's recommendation is 12 months to serve 15 days. Credit for time served 2 days with the balance probated and anti-theft course. And we'd like these positions to run concurrent.
Right. And yes, Mr. Dotis, tell me about the 2 days.
So, Your Honor, I spoke with ASG Allen. It should read, now that's been negotiated, it should read serve 28 days, credit for 14 days. I don't think the offer, it didn't include the time he served for the failure to appear charge, which is related to the underlying charge. So to clear it up, we did agree to just saying serve 28 days, credit for 14 days. And as I explained to Mr. Bethea, with the 2-for-1, that would end his jail time once this plea goes through.
And that is correct. This defendant has served 12 days on the FTA because he failed to appear before you on November 29th, 2022.
All right. Yeah, it'll be served 28 days, credit for time served 14 days. So, and I've got a Pennsylvania address from Mr. Bethea. Would he be staying in Georgia to complete his probation?
Yes, Your Honor. He, one second, if I don't answer this, we should talk. So after speaking with Mr. Bethea, he is currently waiting for his application to go through at a address in Buckhead. He had that application suspended while he dealt with this matter, but he will have an address in Georgia upon release. And I will provide him with probation's contact information, and he knows as soon as he has that address listed to give them a call as well as with the court to make sure that.
Does he have a temporary address right now?
No, I'm still moving from Pennsylvania to.
All right, we'll have to live with your Pennsylvania address, but you have to report to Fulton County Probation once a month in person.
Yes, ma'am.
All right. Okay, and Mr. Doris, do you accept the terms of this plea? And do you
Yes,
stipulate?
we do stipulate, sorry, I didn't mean to cut you off.
That's okay.
I do stipulate to the 3 elements for the purpose of this plea. We would also request if Mr. Bethea could switch to non-reporting status upon completion of conditions. And if the court could help him out by waiving some probation fees while he completes probation and gets settled into his new residency in Georgia.
Where has he been? Isn't he employed?
Your Honor, he's been back and forth. He's been trying to get set up here. He's been having temporary housing, and this has kind of derailed everything, which is why we're resolving it so we can get back on track. The Pennsylvania address is his mom's address. I do have contact information for her.
That doesn't tell me whether he's employed or not, Mr. Dotis. I'll waive probation fees if he was in he's been MIA for a while, and then he's been in jail for 2 days because of the bench warrant. So unless he's indigent to the point of not being able to pay his probation fees, I'm denying the request for a waiver of probation fees.
Your Honor, my client understands he's fine with paying for the probation fees. He says that he can.
Okay. Mr. Bethea, have you consumed any medication or alcohol?
No, ma'am.
And have you understood the proceedings so far?
Yes, ma'am.
Are you satisfied with your attorney?
Yes, ma'am.
And is anyone forcing you to take a plea today?
No, ma'am.
If you decide to enter a guilty plea, nolo contendere plea to these charges, you would have to give up your constitutional right to a trial in front of a judge or a jury. You will not be able to confront your accuser, examine witnesses, challenge the state's evidence, and have the state carry its burden to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to one count of hindering a person from making an emergency phone call and theft by taking?
No, like.
Repeat.
No.
All right. Your sentence for the hindering a person from making an emergency phone call is 12 months to serve 28 days.
Your Honor, I'm sorry to interrupt you. I just was notified by pretrial that this defendant took a NOLO earlier this month in Brookhaven for that driving
what?
while suspended. I just
To
want to
what?
be clear for the court.
That's fine. This is not a traffic offense. The 5-year rule doesn't apply here.
Okay.
Thank you. I'll accept a NOLO contemporary plea and its sentence is 12 months to serve 15 days, serve 28 days, credit for time served 14 days. He'll report to probation upon being released from jail next week. While at probation, he will update the court with his address, his contact number, and his email. While at probation, he will also complete 2 anger management classes at his expense and have no further contact with Zachary Curtis. No illegal drugs, alcohol to be consumed, and not to possess any weapons or firearms. On the second count, theft by taking is a concurrent sentence. It's 12 months to serve 28 days, credit for time served 14 days. Mr. Bethea is to complete an anti-theft class at his expense. And once he's completed the anger management classes and the anti-theft class, his probation will be non-reporting. But he would need to make sure he stays away from Zachary Curtis. Thank you.
Thank you, Your Honor.
Next, Your Honor, we have position number 14, Mr. Keyshawn Howard, 14.
And Your Honor, this will actually be a negotiated plea after further conversations with the state.
Okay. Keyshawn Howard is 23 CR 002064C, accused of battery, domestic violence. From April 4th, 2023. Mr. Howard, you've been advised of your right to remain silent, and your attorney is going to be Mr. Dodis. Actually, I promised Ms. Zakia Watson Cafe her. Is Mr. Pugh around? He really needs to be next on deck, okay? All right, so getting back to Mr. Howard, this is going to be a negotiated plea. Mr. Howard, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. Ms. Duncan, what's the plea recommendation?
Yes, Your Honor. In this case, the state is offering or has negotiated 30 days credit for time served, 15 days. With the stay away from the incident location, no further contact with the victim, balance probated to complete an FVIP course, and that's under the condition that the probation be reporting. In this case, it's position 14, so the incident location is going to be, incident location is 4001 Lakemont Drive Northwest, apartment 32G. And the victim in this case is Sierra Taylor. That's SIERRA, last name Taylor.
All right, thank you. Ms. Dodis, are those the terms to which your clients agree?
Your Honor, my client has one question, if I could answer that.
Go ahead.
Thank you. Thank you, Your Honor. All questions have been answered. We're prepared to go forward with the plea.
Do you stipulate to the factual basis, venue, and ID?
I do stipulate to the 3 elements for the purpose of the plea, Your Honor.
Mr. Howard, have you consumed any medication or alcohol?
No, ma'am.
And have you understood the proceedings so far?
Yes,
Are you satisfied with your attorney?
I am.
And has it been explained to you that if you plead guilty to a battery domestic violence, that would go on your record, and any subsequent arrest for a similar offense will automatically be a felony?
Yes, ma'am.
And it has also been explained that you will have to give up your right to a trial, to confront your accuser, challenge the state's evidence, present your own defenses, and examine witnesses. These are all rights you would have to give up, including the right to have the state prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to one count of battery, domestic violence?
Guilty.
Your sentence is 12 months to serve 30 days, credit for time served 15 days. You are not to return to 4001 Lakemont Drive, the entire complex in Atlanta, Georgia, not just the victim's apartment, but the entire complex. You also to have no contact with Cielo Taylor. You have to stay 200 yards away from her. Do not communicate with her, either in person, through a third party, through a phone, computer, or even on social media. No illegal drugs, no weapons, no firearms. Thank you. Oh, I'm sorry, one more thing. You need to complete your domestic violence intervention program classes. So while on probation, you need to start those classes within 60 days of being released. And they would have to be done at your expense. Thank you.
And Your Honor, if possible, could this court give Mr. Howard a break on his probation fees so that he can make sure that he can afford his FVIP classes? Mr. Howard did tell me that due to his time in custody, he has lost his job. So any break that this court could give him would be appreciated to help him get back on his feet.
April and May. No waiver fee, no probation fees for April and May.
Thank you, Your Honor.
Thank you.
Okay, thank you.
Absolutely.
Next, Your Honor, we have Christopher Pugh, position 29, 30, and 32.
Ms. Watson Cafe?
I'm here.
Oh, excellent. Thank you. So we have Mr. Pugh in courtroom 2. Are you able to see him?
Oh yeah, I am. Yep.
Okay. Did you need to confer with him, or are we ready to proceed?
No, I have already spoken with him. I'm ready to proceed.
Okay, and what are we doing?
We have a plea, Your Honor.
Okay, understood. So Mr. Pugh has 2 cases, 23 CR 002-088F, in which Christopher Pugh is accused of criminal trespass from April 5th of this year. And he's got a bench warrant, 23 FTA 295, warrant that was issued on February 24th, 23. That doesn't make sense.
Yeah, I'm not sure what that's about, Your Honor. I've appeared on his behalf. I was unaware of any bench warrant being issued. I learned only because this case was placed on this calendar, so
All right,
not sure why that was issued.
He's got a prior case, 21 CR 003335F. And he was given a bench warrant in this case. It was a charge of theft by receiving stolen property, incident date July 9th, 2021. There was a failure to appear on February 24th, 2023 before Judge Richardson. And the warrant was issued for his arrest. So that's the outstanding warrant in another CR case. Did you want to reset it to address both cases? Because he'll still be in custody on that bench warrant. And his next court date is April 18th, sorry. He doesn't have a court date with Judge Richardson.
Yeah, so my understanding is that they were going to, I guess, dismiss the FTA as part of this plea. But again, I don't see how he would have gotten an FTA considering I've appeared on his behalf.
Were you in court before Judge Richardson on February 24th, 2023, this year?
Let me see. February 24th.
So he does not have an FTA on the 21 CR case. The FTA was on the 23, not the 23 CR. It was a different case.
It's a different case?
Yes, I think this case was just added because he was in jail on the.
I have 23-000846 FTA. He's got FTAs all over the place. Let me see.
Case number on that.
See, you're,
Oh, it does say.
you're,
21 CR 003335.
Yeah, you're right. Let me see.
That's what the FTA is for, 23-000864 FTA.
23.
Oh, yeah, it is.
23-000864 FTA is for the 21 CR case.
Right.
I was in court, Your Honor, on that day, 9:30, before Judge Richardson. In fact, I had 2 cases on the calendar that day,
Okay,
so.
he's got a warrant out there.
This name is spelled different. So it's not
Oh, Your Honor, may I jump in and inquire on something on this?
On this case?
Yes, Your Honor, on the calendar in general, they've got his name spelled 2 different ways. So when the calendar was sent to our office and we had a paperwork series.
Can I? No, that's all right, Mr. McLean. Just give me a moment, please.
Okay.
The host, allow me to share screen, please. Share screen, please.
Oh, it's Miss Grace.
Oh, Miss Grace, may I have share screen rights, please? So, what I'm trying to show you, Mr. Watson Cafe, is that there is a bench warrant issued by Judge Richardson. I'm looking at the signed warrant. In the case I mentioned, the one ending with 3335F, the warrant was signed on February 27, 2023, and the allegation is that he failed to appear for theft for the calendar in which the offense is theft by receiving. So like I said, there's a $1,400 bond. And if you believe that warrant was issued in error, then you definitely have a right to bring that before Judge Richardson.
I would, but we've come to, I think it would be resolved anyway if he shouldn't still be held on the bench warrant if he enters a plea today.
The warrants for a different case. The case that you are addressing today is for criminal trespass. Incident date is April 5th, 2023.
And that's where I want to comment on.
Oh, okay. So today, because I thought he had 3 positions on this calendar. I'm confused then. I'm sorry, Your Honor. I thought he had 3, just the 29 and the 32.
29 and 30 and 30.
And 30, okay.
Oh, and 32. The theft by receiving stolen property. So are we doing a global offer on all 3?
Yes. I have an offer for all 3, yes, Your Honor.
Okay. Thank you, Mr. McLean.
Okay,
right.
if she's got all 3 positions, I don't need to add anything.
Understood. Thank you.
Thank you.
Mr. Young, have I confused you sufficiently?
Oh, yeah, and I'm very confused at this point, but let's see if we can figure it out together.
Yeah, please.
The global plea, what can I talk? The plea recommendation in this case for position 29 would be 12 months served, 26 days, credit for time served, 13 days, the balance probated, and to stay away from 464 Windsor Street Southwest, that is the BP gas station. In exchange for the plea, would be no crossing position 30, which is the FTA, and for position 32 to run concurrent to position 29, it's 12 months probation, 26 days credit for time served, 13 days, the balance probated, and a anti-theft course.
All right. Mr. Kia Watson Cafe, I'm so sorry to have confused you, but I got thrown off by the bench warrant. And
No, it's fine.
do you stipulate to the factual basis, venue, and ID?
We do, but it's somewhat I guess it's technically non-negotiated. As far as the special conditions, he does not have an issue with that. But we were looking for it to be suspended on position 29. Credit for time served, 12 months, but for the remaining to be suspended. And then position 32, we would ask that it be terminated after he complete the anti-theft course.
I'll put him on non-reporting, but I'm not going to suspend it.
Okay.
All right. Shall I proceed?
Yes, I just want to confirm, Mr. Pugh, do you understand that it's going to be non-reporting instead of terminated? Are you still wanting to go forward?
Mr. Pugh?
Yes, Your Honor.
If you complete the anti-theft class, then your probation will be non-reporting, which means that you are technically still on probation, but you don't have to report. But that's only after you finish the anti-theft class.
Yes, Your Honor.
So as long as you haven't done it, you will need to continue reporting to probation. Do you want to plead guilty under these terms, or do you want a trial?
Guilty, Your Honor.
All right, Ms. Watson Cafe, shall I proceed?
Yes, Your Honor.
Mr. Pugh, have you consumed any medicine or alcohol recently?
No, Your Honor.
And have you understood everything so far?
Yes, Your Honor.
And are you satisfied with your attorney?
Yes, Your Honor.
If you decide to plead guilty to the two cases before you, you would have to give up your constitutional right to a trial, to go back to court, to have an attorney help you challenge the state's evidence, present your own defenses, confront your accuser, examine witnesses, and have the state try to prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, Your Honor.
How do you plead to one count of criminal trespass in 23 CR 002088F?
Guilty, Your Honor.
Your sentence is 12 months to serve 26 days, credit for time served 13 days. You'll be on probation and you need to stay away from the BP gas station at 464 Windsor Street in Atlanta. How do you plead
Your
to-
Honor,
Yeah.
I'm sorry. Are we able to waive the first, or as many as we can? He's currently residing in a shelter. And so he doesn't have the
April-
financial wherewithal.
April, May, and June will be waived.
Thank you, Your Honor.
And for position 32, Mr. Pugh, how do you plead to one count of theft by receiving stolen property from July 9th, 2021?
Guilty, Your Honor.
Your sentence is 12 months to serve 26 days, credit for time served 13 days. You'll be on probation to complete the anti-theft class at your expense. I will waive your probation fees for April, May, and June. Your probation will be non-reporting. If you haven't done the class by end of June, you would have to start paying probation fees from July 1st onwards. Do you understand?
Yes, Your Honor.
The bench warrant issued from case 21 CR 003335F is null pros. Thank you.
Thank you, Your Honor. May I be excused?
Yes, thank you very much. You have a good day.
Thank you, Your Honor. You too.
For North, who do we have?
Position 19 and 20, Mr. Kendall.
Demontre Kendall, position 19 is 21 CR 002680J, accused of carrying a concealed weapon and violations of rules regarding pedestrian and roadway. And position number 20 is a bench warrant that was issued on January 23rd, 2023. Mr. Kendall, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you is Ms. Maureen McLeod. Ms. McLeod, is this going to be a negotiated plea?
No, Your Honor.
All right, what are we doing then?
He's going to be arraigned.
Okay. Do you waive a reading of the accusation?
Yes, Your Honor.
Okay. Mr. Kendall, with regards to both cases, you have been advised by your counsel, and these are the charges that have been brought against you. You are deemed innocent. You are presumed innocent of these charges until your case goes to trial. Upon your entry of a not guilty plea, the cases will be scheduled for trial, at which time then the state, the prosecutor, has the complete burden to prove the charges against you beyond a reasonable doubt. If the do I have your attention, sir?
Yes.
If the state proves the charges against you beyond a reasonable doubt, then you could be convicted and face a sentence of up to a year in prison and or up to $1,000 fine for each convicted offense. Given this information, how do you plead?
Not guilty.
Your case has been arraigned. It's going to be further notice for jail jury. Thank you, Ms. McLeod. Thank you, Mr. Kendall.
You're welcome, Your Honor. That concludes my business before the court today, Your Honor. May I be excused?
Yes. Thank you, Ms. McLeod. You have a good day.
You too.
Next, y'all, you have position number 15, Cedric Jackson.
Cedric Jackson. Mr. Cedric Jackson is accused of criminal trespass in 23 CR 002-066Y. Mr. Jackson's been advised of his right to remain silent, and his attorney is Mr. Dotis. This is going to be a negotiated plea. May I place you under oath, Mr. Jackson?
Yes, ma'am.
Raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. Ms. Duncan, yes, ma'am?
Yes, Your Honor, in this case, it's my understanding that the defendant is not being held on this, but a felony probation violation. So the state's recommendation in this case is 12 months to serve, 30 days, credit for time served, 15 days with the balance suspended. Stay away from the incident location, which is 2424 Piedmont Road Northeast. And if I'm correct, that is the Lindbergh MARTA station.
Okay. Mr. Dotis, does your client accept these terms, and do you stipulate to the factual basis, venue, and ID?
Yes, Your Honor, we do stipulate to the 3 elements for the purpose of the plea. My only diversion from the offer would be to word it as comply with active MARTA suspensions, so that once those are resolved, Mr. Jackson won't have any issues navigating through the city.
I can do that. Stay away from all MARTA in accordance with active suspension, okay? All right, Mr. Jackson, have you consumed any medicine and alcohol?
No, Your Honor.
And have you understood the proceedings?
Yes, ma'am.
Are you satisfied with your attorney?
Yes, ma'am.
And is anyone forcing you to do a plea offer today?
No, Your Honor.
If you decide to enter a guilty plea, you would have to give up your constitutional right. You will not have a trial in this case. You will not be able to have assistance of counsel, to confront your accuser and examine witnesses, to challenge the state's evidence or present any defenses if you choose, and have the state try to prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to 1 count of criminal trespass?
Guilty.
The sentence is 12 months to serve 30 days, credit for time served 15 days, balance suspended. Do not return to any MARTA property if there is an active suspension against you. Thank you.
Yeah. Next, Your Honor, we have position 35 and 36. Mr. Shannon Ryder.
Mr. Ryder is
position 35 and position 36.
Thank you. 22 CR 007-105D, Mr. Ryder is accused of DUI and speeding. And in the position 36 is a bench warrant 23 FTA 304 issued on February 17, 2023. Mr. Ryder, you've been advised of your right to remain silent. Your attorney is Mr. McLean. Mr. McLean, how are we proceeding?
The state had mentioned 2 routes and he'd like to do a negotiated plea for the DUI court, Your Honor.
All right. So he'll be reporting to DUI court for monitoring then as opposed to probation?
I believe they, I'm not sure how many sessions a month they have, but essentially, yes, Your Honor. I don't even know, it's been a while since I've dealt with DUI court matter. I'm not sure that JCS is doing the supervising, but he does go to the judge that he's assigned to, and they have classes and meetings, and it's an accountability court, of course.
Miss Allen or Mr. Young, do you know if DUI court has accepted him as a candidate?
I am unsure, Judge.
All right. Mr. McLean, it's difficult at this juncture for me to sentence him accordingly or contingent upon him entering DUI court unless there's been, they have a program where they have schedules where individuals show up. Based on that, probation, all the social workers and so forth all come to the scheduled dates as opposed to just reporting to probation once a month.
Right, I told him that there would be a regular schedule and there would be content, real content.
But I don't know whether he's been registered as a candidate for DUI court or even accepted. So I don't know whether he is, if I tell him you can go to DUI court and he's not a candidate, then he has nowhere to report. And that's not fair to others.
Right, do we have a liaison between the solicitor and the DUI court where he looks like he's eligible? That sort of thing that we could do.
I'm sorry, repeat that?
Do we have some sort of liaison or eligibility criteria? Because that's the route that was the offer that he says, I'd like to take that offer.
Is Judge Taylor doing the DUI court?
I believe Judge Taylor and used to be Judge Taylor and Edline.
Judge Taylor and Judge Edline do DUI court. So
They're
if you want to confirm that he's a candidate for DUI court, they can also schedule him and sentence him accordingly. But I'm not going to sentence him on a contingency.
Right, it is a D case anyway. I could get hold of the public defender who's assigned to Judge Edline and see how fast this could be done. Today is Tuesday. Maybe.
Because otherwise, if he's not in DUI court, then you have an alternative recommendation.
Right, that involves time, Your Honor, and he would rather be out. And he is willing to jump through all the hoops that would enable him to be out. So if there is no way to do this today, Your Honor, can we do it 2 days from now on Thursday?
Yeah, we'll reset it to Thursday.
And Your Honor, I'm looking at our case notes. It looks like in January of this year, there's a note from the prosecutor in that courtroom saying that this is the second DUI in 10 years and the third in life. Therefore, this defendant qualifies for DUI court, and that as a pro se defendant in January, he reached out to the attorney in that courtroom for a recommendation, and she mailed him a copy of the discovery and a DUI court offer letter, including non-DUI court letter. So he was given that information and offered DUI court and told he qualified in January by the attorney in that courtroom.
Okay, he was qualified, but he didn't send the paperwork in to be given the schedule and so forth, right?
Correct.
Okay. Reset to April 20th, and once it's confirmed, then Mr. McLean, you would need to get the court dates for DUI court, so they have him on the roster.
Thank you, Your Honor.
And that would be the 20th for a plea and to enter DUI court.
Very good. Thank you.
Thank you.
Next, we have position number 44, Donald Thompson.
No, are you gonna do the not guilty? Yeah, that's right. Or are you gonna do the? You want this?
Deputy, are those new folks being brought in for this calendar?
No, they went to use the restroom, Your Honor.
No, the folks were seated back there.
Yeah, no, they were using the restroom. And they're back.
Okay, but were they advised of their rights?
Yeah, they were. Everyone,
Okay.
all of them were in here since the beginning.
Okay, thank you. I may be on the wrong case. I stopped at 39. Is that correct?
I'm doing 44 right now.
44.
Yeah, I had to rearrange it since those guys went to the
Oh,
restroom.
Donald Thompson, 44, and was there a bench warrant as well? No, okay. All right, Mr. Donald Earl Thompson is 21 CR 003-890D. Mr. Thompson's been accused of DUI and failure to maintain lane from November 16, 2019. Mr. Thompson, you've been advised of your right to remain silent. Your attorney is Mr. McLean. And Mr. McLean, on this particular case, 44. Okay, it says hold for Attorney McLean to report. So, yes, sir.
I'm trying to make sure that Mr. Thompson understands the 2 or 3 different options, the unnegotiated plea. The state has made him a new offer that is improved. And he can go with the negotiated plea that would entail 31 more days in jail instead of 46. And then all the other requirements of a DUI plea. Or a negotiated plea or not guilty. So do you understand that none of these, except for asking for an unnegotiated plea in which you can ask the court for any result, none of them involve going home tonight as a practical matter? I think he's a little confused, and I hope that the confusion is not great.
All right.
So do you feel like you have a clear understanding of what we're doing here today?
No, can I make my explanation?
Well, there's the 31 extra days. The unnegotiated plea, which you talk to the court and see what it looks like. And then there's simply the not guilty and make your bond. And you won't be able to make your bond until you get your paycheck on the 1st, which is 12 days. So none of these really, practically speaking, involve freedom tonight. Just be real about it.
But if I make bond, then mean I have to go to a trial.
Trial would be later. You watch your mail like a hawk. You keep up with the clerk and you'd never miss a court date, and you would go to trial later on. Or even at that trial, you could still talk to the state about a plea bargain, but it might be the same, might be different. We don't know.
Okay, Mr. McLean,
Yes, sir.
he's got a extradition warrant. All right, just FYI. From Hamilton County, Chattanooga, that would be Tennessee, yes?
I think Hamilton County is Chattanooga. I think, did you mention, was it a minor matter? The Chattanooga business?
Yes, I thought that was taken care of, because I know I just had to pay for that.
And you
Okay.
did-
So right now, he's got an extradition warrant from Tennessee. He's got a $4,000 bond on these DUI charge and the failure to maintain lane change. I'm going to reset the case to April 20th. And if he decide, and once you can explain to him his options, considering the current hold and so forth, we can address this. And I've also been informed that this is his 3rd DUI conviction in 10 years. So his 3rd DUI in 10.
The state may have some additional detail on that.
And I hope that we can address that on Thursday.
Okay.
We will address it on Thursday, Jan. I need to double check that because I wasn't seeing the 3rd DUI, but I need to look again. It was a crazy
Okay.
day yesterday.
It's a note on my calendar, so thank you.
Thank you, Honor.
Next case, please.
Position 8.
All right, we have, we're moving to 5 North, and we have position Mr. State versus Ronald Dorsey, accused of battery, domestic violence in 23 CR 002110A. Mr. Dorsey, you have a right to remain silent. Anything you choose to say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you presently is Mr. Dodis. Do you see Mr. Dodis in courtroom 2? You need to say yes or no.
Yes.
Thank you. Mr. Dodis, how are we proceeding?
Yes, Your Honor. I sent an email last night to Michael Jordan. I wanted to check to see if he saw that email regarding Mr. Dorsey's jailing screen. On this, it looks like he has 2 cases, one of them being this case that was originally in Superior Court. Both of those cases were transferred down to state court. And they're still showing as the Superior Court case number holding him in Odyssey. But one of those cases was resolved in September, and he's still listed at no bond status. And then this case we could resolve today, but I want to make sure that the no bond error has been resolved. I know that was a lot. Apologies if that was confusing.
All right, but you asked Mr. Jordan, so I'm going to defer to him since
Thank
he's right here. I have a 22 CP 206822. That was bad.
It was 820.
Sorry, Mr. Jordan.
22 CP 206820.
2068. Yeah, that's 206820 and 206822.
Oh, he's got 3 cases.
And then he's got an inmate related matter, 22 CP 213664. And 680 was transferred. 81. And 22 CP 206817 was transferred.
Holding on the one from 6817 6820.
Oh my goodness, the case not coming up. Did I sign it? No. Excuse me, he's got a $5,000 straight bond on that case that was transferred back to state court.
Right, and that's the case that we could resolve today, but I also see that he's held no bond on 22 CP 206820. That case was transferred to state court and the final disposition was entered in September, and I think I sent that to Mr. Jordan. So he's been no bond status for 4 months on a case that was resolved in September. Or not, I want to make sure that's resolved so that we can potentially resolve this case and not keep holding it here.
All right. So on April 19th, 2022, bond was denied after his first appearance. No. At his preliminary hearing after first appearance. And then, so he was in no bond status from April 19, 2022 until September 21st, 2022, when the district attorney's office decided to transfer it back to the state court. Oh, bummer, but they didn't specify a bond.
Right. And then that case was, the final disposition, I think, was entered September 27th. So there was no need to address bond because they had a resolution, so they closed it out, but that wasn't reflected in Odyssey for whatever reason.
So what would you like us to do, Mr. Doty?
Well, I need to, we could resolve this case, we could resolve position 8, which is what's holding him on a $5,000 surety bond with the time served offer. But if I do that, he's still going to be held on this no bond hold for a case that was resolved months ago. So I don't want him to get lost in the system for another, 9 months like he has been. He could have bonded out in this time.
Okay. So, Miss Allen, by any chance, would you have the accusation numbers or the equivalent state court case numbers from these transfer cases?
I do, Your Honor. So the case that was transferred, 22 CP 206820, the one you are just looking at, where there's no bond given after the DA's office transferred back a battery with a date of incident February the 20th of 2022. That was disposed of in September of 2022 in 22 CR 006463A.
Okay.
I'm pulling up the final disposition now. It is closed in Odyssey.
So that case is not holding him.
Not as far as the state is concerned or the court. Credit for time served.
All right. So what about 22 CP 206817 with the $5,000 bond?
Moment.
That was transferred on September 7th, 2022 to state court.
One moment. I'm pulling it up.
And that was for?
It's a date of incident of April the 7th, 2021.
Yeah.
That
So
is,
that would be the current case then, 21108.
yes.
Okay, and he has a $5,000 bond in that case. All right, Mr. Dotis, do you know of anything else that's holding him? Those are the two that I see holding him in state court.
No, Your Honor, but that one that we're saying 22 CP 206820 that did become 22 CR 006463A. My issue is that on the jailing screen of Odyssey, and when I look it up in jail records, it's still listed as no bond status. So that needs to be dealt with. And I understand that we all have records.
Okay.
Of the
Give me a moment. Give me a moment, please. Thank you.
I'll send the email to jail records, Judge. It looks like they got confused with that particular case.
Yeah.
So I'll send them the final disposition
BR
on the CR case.
006463A.
So they added the time served to the jail screen. They just didn't add it to the right charge. The 22 CP case.
Mr. Dotis, if you will just send me a proposed order vacating the bond in 22 CR 006463A, as that case has been disposed of by a plea on September 29, 2022.
Yes, Your Honor, I can do that.
All right, so we can have any bonds as holding him in that case removed. So that takes care of that matter. We are back to this one, 2110A. What are we doing?
Yes, Your Honor. I spoke with Mr. Dorsey yesterday. I wanted to make sure that we squared away the issue with bond, so I'll ask Mr. Dorsey today. You do have an offer, and I'll let Ms. Duncan read that offer to you, but it would be time served, so you should be processed out of the jail system today. I don't need more hold.
All
So
right.
the choice is yours. How much you want?
Ms. Duncan, what's the proposed offer for 2110A?
The state's offer in this case is time served 422 days. No further contact with Shakari Storers. That's SHAQUORIA. Last name STOWERS. And her, at the time, 16-year-old son, who's the other involved party, and to stay away from 4900 Delano Drive, apartment 6C.
I'm good, if you don't mind, just because it's a misdemeanor, I'm going to have it as 12 months to serve, credit for time served 12 months, no further contact with. Well, he's already served the 12 months. I won't be able to impose a no further contact. She would need to go to Superior Court and obtain a protective order.
That's fine, Your Honor. We'll handle that. Thank you.
Okay. And Mr. Dotis, does your client accept these terms?
I'll ask Mr. Dorsey, do you want to go forward with this offer?
Yes, sir.
Okay, Mr. Dorsey, do I have your permission to fill out the paperwork on your behalf?
Yes, sir.
Okay, the Judge Law is going to ask you a few questions. I'm going to fill out the paperwork with your answers to those questions. Do I have your consent and express permission to sign that document and send it to the judge?
Yes, sir.
Okay, thank you.
All right, Mr. Dorsey, do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Well, I could ask you how to make roast chicken, but Mr. Dorsey has probably got one ear paying attention to this, so let's go with this. Mr. Dorsey, have you consumed any medicine or alcohol recently?
No, ma'am.
And have you understood the proceedings so far, especially with all the other open cases that were supposed to have been closed?
Yes, ma'am.
And are you satisfied with your attorney?
Yes, ma'am.
Is anyone forcing you to take a plea in this case today?
No, ma'am.
And you understand that if you decide to enter a guilty plea, that it would be a battery family violence conviction on your record. Any subsequent arrest for a similar charge will automatically be a felony charge.
Yes, ma'am.
And do you understand that if you take this plea, that you would have to give up your constitutional right to go back to court, have a trial, confront your accuser, examine witnesses, challenge the state's evidence, and have the state try to prove the charge against you beyond a reasonable doubt?
Yes, ma'am.
How do you plead to one count of battery, domestic violence in 23 CR 002-1108?
Not guilty.
So, Mr. Dorsey, as we discussed, if you want to go forward with this plea.
Sorry, I'm gonna plead guilty on this.
Your sentence is 12 months to serve 12 months. Credit for time served 12 months. So your jail time for this case is concluded, and that closes out the case. Mr. Dorsey, the prosecution has indicated that they want you to have no contact with Shakari Storers
Yes, ma'am.
or her son. Is that your child also?
No, ma'am.
Okay. So I would recommend that you stay away from her just to avoid you coming back to jail, unless you've just found it to be such a pleasant experience. Then it's completely up to you.
No, ma'am. Thank
All
you.
right. Mr. Doris, go ahead and send me the plea paperwork for 2110A and the proposed order vacating the bond based on the disposition for the case ending in 6817A. Oh, no, sorry, 464638. My God, I got a lot of case numbers written here. Sorry.
I'm from the doozy, Your Honor. Thank you for bearing with us on this.
No problem. Thank you. Next case, please, Deputy.
Next is going to be position number 38, Mr. Victor Salman.
So they got my other charges.
They still got to correct it, but it's in the process.
5 North, we can mute. 5 North, we can mute. Thank you.
Is aware now.
Right.
So
5 North, we can mute, please.
So,
Host, Ms. Grace, thank you.
The young one is very clear.
All right, Mr. McLean, we have your client, Victor Salman, 16 CR 012751B. traffic-related matter, failure to signal lane change and unregistered vehicle from August 26, 2015. This is going to be, it looks like a time served plea. Is that what your client wants to do?
Yes, Your Honor, relatively simple for today. A time served, balance suspended, negotiated plea in which he stipulates the 3 elements and asks the court to accept his plea.
Okay, Mr. Salman, you've been advised of your right to remain silent, and your attorney is Mr. McLean. Mr. Young, are these the terms to which the state's offering?
That's correct, Your Honor. The plea is a time served, plea 12 months, served 15 days, credit for time served, 8 days, the balance suspended, no operation of a vehicle without a valid license, registration, or insurance.
Okay, and Mr. McLean, you indicated you stipulated factual basis, venue, and ID, correct?
Correct. That's correct, Your Honor.
Mr. Salman, could you please raise your right hand, sir? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
Have you consumed any medicine or alcohol recently?
No.
And have you understood the proceedings? Mr. Salman, have you understood the proceedings?
Yes.
Are you satisfied with your attorney?
Yes.
And has it been explained to you the rights you have to give up if you decide to take this plea?
Yes.
And have you understood the explanations given to you?
Yes.
How do you plead to failure to signal lane change and operating a vehicle without proper registration or license plate?
Guilty.
Your sentence is 12 months to serve 15 days, credit for time served 8 days, balance suspended. You don't have any jail time, and that concludes your case, but do not drive until you have a valid current license, you have insurance for the car you're driving, and the car is registered.
Yes, sir.
Thank you.
Thank you. All right.
Next case, please.
You'll be kicked out of jail tonight. You don't have anything on you.
Thank you, Your Honor.
Thank you. We done?
Oh, no, we have several more.
We have several more, Your Honor.
Okay, sir.
Position number 40, Mr. Stevens, position number 40.
When you say several, is that like a dozen or less?
It's about 4 more.
Okay.
I'm trying to get the misdemeanor done also.
Okay, thank you. We have Mr. Material Stevens, 19 CR 002776Y. Mr. Stevens, you have 5 misdemeanor charges brought against you from May 27, 2017. You've been advised of your right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and Mr. McLean will be representing you. How are we proceeding, Mr. McLean?
Well, there was one question first off the bat, Your Honor, and he wondered if the court might allow him to propose a unnegotiated plea. And if it's pretty much what the state is asking for at the present time, he was wondering if the court would allow him to withdraw it. And I told him.
Oh, this is a non-negotiated plea then. So first I'm going to hear from the prosecutor. Mr. Young, what's the plea offer for Mr. Stevens?
Your Honor, the plea in this case for Mr. Stevens, count 1, criminal trespass, 12 months to serve, credit for time served, 2 days, family violence. Intervention program, no further contact with Kimberly Stevens. The simple assault family violence, 12 months served concurrent with count 1, the hindering person making 911 phone calls, 12 months to serve concurrent with count 1. Stalking family violence, 12 months probation consecutive to count 1. And battery family violence, 12 months to serve concurrent with count 1 for a total of 24 months probation, 12 months served, credit for time served, 2 days, family violence intervention program. No further contact with Kimberly Stevens, and stay away from the incident location. And I can get you that address momentarily.
All right. And Mr. McLean, what is your client seeking instead?
He was in this mode, Your Honor. This did happen in 2017, whatever did happen. He was asking if he could get time served and even more probation and more classes and more community service. But he has a business, he has an employee, he has a lawn care service. He has Martell Russell working for him. He says he stayed out of trouble for quite some number of years. This was literally within a month of 6 years ago. And he understands the FVIP is expensive and long, and will do that faithfully. He just wondered if he could get out tonight.
He needs to, the way I look at it, he needs to report to probation the first year. And if he completes all his conditions like the FVIP within the first year, then I will place his second year on a non-reporting status. But he will be on active probation the first year and non-reporting status as long as his classes are completed. Is that something you'd like to consider?
I think that's exactly what he's proposing, Your Honor. That would be great.
Any objection, Mr. Young?
Objection to the non-reporting after the completion of the
Classes, yeah,
violence?
but it's it's active probation for the first 12 months. And then the second set of 12 months is non-reporting if he's completed FWIP in the first year.
State has no objection.
All right.
Okay.
So, Mr. Stevens, please raise your right hand. Do you solemnly swear the information you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. Mr. McLean, do you stipulate to the factual basis, venue, and ID?
We certainly do, Your Honor, all three.
Mr. Stevens, have you consumed any medicine or alcohol recently?
No, ma'am.
And have you understood the proceedings so far?
Yes, ma'am.
Are you satisfied with your attorney?
Yes, ma'am.
And is anyone forcing you or inducing you to take this plea today?
No, ma'am.
If you decide to enter a plea today, you would have to give up your constitutional right to try these charges in a court of law. There won't be any attorneys to assist you to challenge the state's evidence, confront your accuser, examine witnesses, and have the state try to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to criminal trespass, family violence, simple assault, family violence, hindering a person from making an emergency phone call, stalking, family violence, and battery, family violence?
Plead guilty, ma'am.
All right. Your sentence is on the stalking, family violence. The sentence is 12 months probation consecutive with count 1. With regards to count 1, your sentence is 12 months to serve. How many days was it? Was it 4 days?
He's really been in now, how long?
11 days.
About 11 days he's been in now, bro.
All right. 12 months to serve 22 days, credit for time served 11 days. For the first 12 months, he will be on active probation. He is to complete the 24-week domestic violence intervention program classes at his expense. And he's to have no contact with Kimberly Stevens.
Yes, ma'am.
With regards to the stalking matter, it's going to be consecutive to this sentence. And if he completes the FWIP classes, then the next 12 months will be non-reporting probation, although he still needs to continue to not have any contact with Kimberly Stevens.
Yes, ma'am.
Counts 2, 3, and 5 are all going to be 12 months of serve concurrent with count 1.
And Your Honor, if they have a child together, I will explain to him the third party business if that's something that the court needs to go into.
All right. Mr. Young, what was the location from where he has to stay away?
The incident location is 250 Valley View in Fairborn, Georgia.
Valley View Drive in Fairburn, Georgia?
Yes, Judge.
Okay. Now, Mr. McLean, you need to explain to your client, Mr. Stevens, that if he shares a child or children with Ms. Stevens, that she is the custodial parent and she has an absolute right not to engage in third-party transfer. If he wants to have joint custody or visitation with any child or children that he shares and she refuses, then he would need to file a legitimation action.
But no, the reason I bring that up, Your Honor, is they actually are still legally married.
Oh, okay. In that case, then I will allow for third-party transfer unless she obtains a different court order from
Correct.
Superior Court. Thank you.
Thank you. Sorry. That means that you can't ever see Kimberly. Okay. So what?
Okay. Next case, please.
Next, Your Honor, we have position 41, position 42, position 43. That's gonna be Mr. Circuit, Eddie Circuit.
All right. Ms. Strong, this is from that house guy. Just check him. We have Eddie James Circuit. Position 42 is 23 CR 0002051 F, in which he's accused of theft by shoplifting on October 28th, 2022. Note that he has 2 previous theft by shoplifting convictions. Position 43 is a bench warrant, which will be null prost if he takes a plea on position 41 and 42. Position 41 is State versus Eddie Circuit as another theft by shoplifting, also from October 28, 2022. This appears to be, are these duplicative cases? Same location, same address, same date?
He only recalls 1 arrest and 1 shoplifting, Your Honor. This may be a duplication.
Mr. Young, do you have any information on this?
Your Honor, from what I've been able to discover, it seems like they are the same case, based on what I found in Odyssey last night. The same incident reports, the same warrants, all the same information. Only difference is the case numbers, and even the offense dates are the same for both offenses.
All right, someone needs to make a decision if I can go with 2051, no, excuse me, 2012. I can go with case 22 CR 007429 F as the earlier case number and dismiss the subsequent case number 23 CR 002051 F as a duplicate. Only if the prosecution verifies that it is a duplicate and they're comfortable with me dismissing the case, which is 99.7% of the time, no. So y'all tell me if y'all are comfortable.
Oh, Your Honor, if I may interject, his memory is, and I checked the police report itself, the only one we had. While there may have been a couple of food items, the majority of this was that Sensodyne whitening kits. And so he does have a memory of it. That's why he's sure that he didn't shoplift twice from the same store in the same day.
Your Honor, if you would, please give us a second to take a quick look to verify before we proceed.
He had 2 first appearances as well.
He's just getting
And where y'all should have just addressed the bench warrant. And that's the only thing I can think of.
It's like a show that was once on TV about identical cousins, Your Honor.
When was the bench warrant issued? Bench warrant was issued November 1st, 2022. I think that's what happened. They created a second case for shoplifting when it should have just been the bench warrant. But y'all can confirm that and then I can get back to it. Mr. Circuit, I'll be glad to address both your cases, but are we doing a plea, Mr. McLean, or what are we doing? Arraigning the case?
Oh, no, it's a plea, Your Honor. He
Okay.
because of the number of days that he served, then looking at the offer on looking at the 30 days with credit for 18, and that would bless him with the situation of not doing 13 more extra days.
All right, I'll wait for Mr. Young to give me an announcement on position 42, and then I can move forward with the plea for Mr. Circuit. Next case, please.
See you in a second. Next, we're gonna go to position number 45, Mr. Arthur Turner.
Okay. Mr. Arthur Lamar Turner Jr. is accused of simple battery on March 1st, 2022 in case 22 CR 001154E. Mr. Turner, you've been advised of your right to remain silent, and your attorney is Mr. McLean. This is going to be a negotiated plea. May I place you under oath?
Yes.
Raise your right hand. Do you solemnly swear the testimony you provide will be the truth to the best of your knowledge?
Yes.
Thank you. Mr. Young?
Yes, Your Honor, the plea record in this case is 12 months, served 10 days, the balance probated, no further contact with Adriana Lidra, and 8-week anger management.
Mr. McLean, does your client accept these terms, and do you stipulate to the factual basis, venue, and ID?
We do so stipulate, and those are the terms, Your Honor. I noticed that in calculating when he would be released, the offer did not include the CFTS, the credit for time served. Now, notice that in the calendar itself, there's a notation that on March 1st and 2nd of 2022, that would be 2 days of credit back then from the spring of last year. He's been in a certain number of days now, and I believe that's going to cover him for the normal 10 days being 2 for 1 and becoming.
I can do 12 months to serve 24 days, credit for time served 12 days.
That works great mathematically.
All right.
No objection.
Do you stipulate, Mr. McLean?
Yes, we do. Thank you.
Mr. Turner, have you consumed any medicine or alcohol?
No.
And have you understood the proceedings?
Yeah, a little bit, yeah. Well, you gotta
Okay.
go all the way with it. Yeah, a little bit.
All right. So what we just did was to give you some credit. So we shaved some time off the 12 months. So you have to about 11 months, 1 week to serve on probation. That's what we did.
Okay.
All right. Are you satisfied with your attorney?
Yes.
And is anyone forcing you to take this plea today?
No.
You realize you'll be on probation to complete anger management classes.
Yes.
And Mr. Turner, has it been explained to you that if you plead guilty today, that you have to give up your right to a trial to be able to confront your accuser, challenge the state's evidence, examine witnesses, and have the state try to prove the charge against you beyond a reasonable doubt? Are you prepared to give up these rights?
Yes.
How do you plead to 1 count of simple battery?
Guilty.
Your sentence is 12 months to serve 24 days, credit for time served 12 days. Balance will be on probation. You are to have no contact with Adriana Ledra. That means stay 200 yards away from her. Do not speak to her in person, through a third party, through a phone, through a computer, and definitely not on social media. Understood?
Yes. Your Honor, could he possibly have a couple of months of the $49 fee of supervision of probation? Not cost us that 8-week will cost us the money.
All right. So, Mr. Turner, while you're on probation, you need to complete 8 weeks of anger management classes. That will take you about 2 months to complete. I will waive your probation fees for April and May. By June 1st, you need to start paying probation fees. And if you complete your anger management classes, any objection to non-reporting?
No.
If you
Nothing
finish
from the
your
state.
anger management classes, your probation will be non-reporting. So the sooner you're done, the cheaper it will be for you.
Okay. All right.
Thank you. Next, please.
Next, we have position 47, Mr. Alex Williams.
So Alex Williams is 23 CR 002075J, accused of battery domestic violence from April 3rd, 2023. Mr. Williams, you have been advised of your right to remain silent, and your attorney is Mr. McLean. Mr. McLean, are you filing a waiver of arraignment, or would you like me to arraign the case?
We'd like to. Yeah. This is not okay. It's a different day. Your Honor, we'd like to waive the formal reading of the accusation, have the court tell him the maximum and the fact that he needs to watch his court.
Mr. Alex Williams, you're accused of the misdemeanor offense of battery, domestic violence, and if you are legally presumed innocent of this charge, upon your entry of a not guilty plea, the case will be scheduled for trial. At the time of the trial, the prosecutor has the complete burden to prove the charge against you beyond a reasonable doubt. If the state prevails, you could be found guilty and be convicted to up to a year in jail and or up to $1,000 fine. Given this information, how do you plead?
Not guilty.
Mr. Williams, how do you plead?
Not guilty.
Your case has been arraigned and is going to be further notice for jail jury. Mr. Williams received a $3,000 cash bond at his initial appearance by Judge Mincy, and the pretrial, please give me his GCIC, please. Ms. Tyson, I'm sorry. what were you saying?
Yes, I'm here. It looks like the defendant had one misdemeanor marijuana possession less than 1 ounce out of Valdosta. He received first offender treatment on that one. Looks like the case was sealed July 2017. He has one violation of probation. And let's see. And I'm not showing a disposition for it, but he has an arrest from September 2021 out of Clayton County for simple battery, simple assault, and criminal trespass. They haven't listed a disposition for that one.
All right, thank you.
Nothing.
And the reason we put down bond request, Your Honor, was that normally when I see a $3,000 cash bond, I'm thinking that this person has bad record or has failed to appear or something like that. But he's been continuously in custody since the 4/3/23, was just several days ago. So he hasn't been out to miss any court. So he would like to have a bond that he can afford, something like either a signature bond or a $1,000 or $2,000 surety bond.
All right,
Yeah.
Mr. Young?
Your Honor, if I may, maybe I can clarify. That Clayton County arrest is with the same victim, from my understanding, based on the fact that the victim in this case told law enforcement that he and the accused was, they had a recent altercation in Clayton County between the two. And so I think that's what he's out on bond for. That's probably why he was hit with a $3,000 cash bond, is because of this cycle of domestic between the two.
All right, but the alleged victim is not a minor, right? I noticed he's 30 years old. Brendan Davis?
Yeah, Brendan Davis.
Okay, all right. And so but what's the prior confirmed case for anything else involving Mr. Davis?
I don't think there is one. I think it's only the Clayton County case from what I've gathered.
All right, thank you. And Mr. McLean, does your client understand that he needs to stay away from the 700 Lake Joyce Lane?
Oh, absolutely, Your Honor. And he does work full-time at a warehouse called DHL, a large company.
Okay. Anything else, Mr. McLean?
Nothing, Your Honor. Thank you.
Bond is set at 3,500. It's going to be I'm sorry, 2,500. I beg your pardon. 2,500 surety bond. No further contact with Brendan Lee Davis, and to stay away from 700 Lake Joyce Lane in Fairburn, Georgia. What that means, Mr. Williams, is that you have to stay 200 yards away from the individual, Brendan Davis, and the location at Lake Joyce, and you cannot return to either one of them. You cannot communicate with Mr. Davis in person, third party, phone, computer, social media, so forth. And once you make bond, you need to update the court with your new address within 30 days of being released. So if you decide to, does he qualify, Mr. McLean, for PD?
We will have to cross that bridge later, Your Honor. We had so
Okay.
many clients last night that with a 48-person calendar, I did not qualify them.
All right, so Mr. Williams, if you do not qualify for the services of the Public Defender's Office, I highly recommend you retain counsel to represent you in this particular matter. Thank you. Oh, no illegal drugs, no weapons, no firearms. Thank you.
Thank you, Your Honor. All right. I'll explain that. Have to make them on. I'll explain more later.
Next case, please.
That's it. That's all we have in our courtroom.
All right. Oh, one more, Mr. Circuit. Mr. Young,
Yeah.
Ms. Allen, do you have an announcement for Mr. Circuit?
And also, what about position 11?
I am still looking at Mr. Circuit. If you could give me a moment.
Okay, then in that case, position 11, Jamal English, is Mr. English in there? Jamal English. That was Mr. McLean's client?
That's, Your Honor, Mr.
Oh, Mr. Dotis?
Mr. English is my client. I haven't seen him on Zoom yet, position 11.
Okay. Let's go down the calendar, and if the jail can advise me as to where position 11 is, Jamal English, and then Ms. Allen can give me an update on Mr. Circuit by the time we conclude with the calendar wrap up, okay? All right, position 1, Allison is a waiver of arraignment and further notice jail jury. Position number 2, the bench warrant is vacated and set aside. Position 3 is a plea. Position 4, null pros. Position 5 is a plea. Position 6, null pros. Position 7 is a I think this was an arraignment and a bond set at 3,500. Mr. Dotis was going to send me a waiver of arraignment and a proposed bond modification for 3,500. Okay.
Correct, Your Honor.
Position 8 is Dorsey, and that was a plea. And we're going to vacate the bond in this other case. Correct?
Correct, Your Honor. I'll have that paperwork ready shortly.
Okay, thank you. Position 9, Duvall is a waiver of arraignment and further notice for jail jury. Position 10, Duvall, the bench warrant, the bond is amended to $7,500 for the bench warrant. Position 11 is hold for announcement. Position 12, Gary was a plea. 13 was a plea. 14, no. Gary was supposed to be a plea. Yes, it was a plea. Okay. 14, Howard was a plea. 15, Jackson was a plea. 16, Jarreau was a plea. 17, Jarreau null-pros. 18, Jones was a plea. 19, Kendall was arraigned. 20, Kendall arraigned. Further notice, jail jury. Position 21, Brian McCormick is released. Further notice. Same announcement for position 22, released for the notice. Position 23 was a plea, 24 was null-pros. Position 25 is a plea. Position 26, Urda. Position 26 is Mr. McLean. Do we have an announcement for Zachary Urada?
I was not able to see him because he was not brought out to the visitation booth, which I waited because he apparently has a medical problem, and I'm waiting to hear more detail about whether I'm going to be able to see him.
Reset to April 25th.
Very good.
27, Parker was a plea. 28, Pinckney was reset to April 25th to determine a plea in his other companion case. 29, Poe was a plea. 30, Poe was null-pros. 31, Katrina Pugh was a plea. 32, Christopher Pugh was a plea. 33, Raglan was a plea. 34 was null-pros. 35, Ryder is reset to April 20th for a plea and a determination whether he may enter, not qualify, but whether he may be entered as a candidate for DUI 4. 36 is reset to April 20th for same announcement. Sagos is arraigned and further notice jail jury. 38, Salman was a plea. 39, Smith, Jesse Smith. Loaned out where? Grady? Mr. Dotis, Mr. McLean, do y'all know? Loaned out medical? Jesse Jerome Smith, DUI.
Your Honor, last week, there was some mention of it being graded. It turns out he's loaned out to the U.S. Marshals, and looking what his charges are, he's got, if Your Honor notices on his jailing, when you click on that Odyssey, I don't know where he's been loaned out to physically. But if he's loaned out to the U.S. Marshals, I just don't expect to see him anytime soon.
Okay, let's give it another shot on April 25th. This is a 2016 case, so please find him.
Right, I had put a big old question mark over his name because.
Okay. Position 40, Stevens is the plea. 41 is hold. 42, 43 are holds. 44, Thompson is reset to April 20th, 2023 for a plea. Just want to also confirm that if this is his third DUI in 10 years. 45 is a plea. 26, D'Amica Warner. What are we doing with Miss D'Amica Warner? Okay. This has been.
My apologies.
I was going to say it's going to be reset for the competency calendar. Is it this week or next Thursday?
This was Attorney Howard's case. He mentioned asking for, he had to step out to go to court, but he told me to ask for the next available competency date, and he's filed the paperwork.
So it has to be at least 6 weeks out then. Reset it to May 25th at 11 a.m. All right, excuse me. Position 47 is arraigned and further notice jail jury. Bond was modified and 48 Wood was released. Going back to Mr. Circuit.
Your Honor, when I look at both the jailing and our case in Odyssey as well as case manager, what I see is a FTA case where a warrant was issued on the 22 CR in December of 2022, and it looks like the 23 CR case is identical and needs to be dismissed.
Okay,
So-
position 42 is dismissed.
Yes.
As a
so-
duplicate, okay? And so we're only going to address 43 and 41. And Mr. Dotis, what are we doing for Mr. Circuit? Is this going to be a plea?
It's a plea, Your Honor.
Okay. Who do I have on the jail court iPhone? Is that? Who's the gentleman at jail court iPhone? I'm sorry, Deputy, could you unmute, please?
Mr. English, Jamal English.
Okay. And Mr. Dotis, you represent Mr. English?
Yes, Your Honor. I met with Mr. English yesterday. He wanted to sleep on it before he made a decision. So I'll leave that decision up to Mr. English. And I'm happy to speak with you if you have any questions.
All right. Do you have your laptop? We can put you in a breakout with jail court.
That's fine, Your Honor. I do have my laptop ready to go.
Okay. Ms. Grace, if you could place Mr. Dotis in a breakout with jail court iPhone. Deputy, you may have to put them in. I'm not sure. If you can move jail court iPhone to the breakout, that'll be appreciated. State versus Eddie James Circuit, accused of theft by shoplifting on October 28, 2022 in 22 CR 007-429F. And then the second case is a bench warrant, which is 23 FTA 299, bench warrant issued on November 1st, 2022. The second case against Mr. Circuit, as we announced, the 23 CR case is dismissed as a duplicate. Mr. Circuit, you are all by your lonely cell. Where did all your attorneys go? There we go. Okay. Mr. Circuit, you've been advised of your right to remain silent, and your attorney is Mr. McLean. Mr. Circuit, may I place you under oath? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. Mr. Young, what's the plea recommendation for Mr. Circuit?
Mr. Circuit, the plea recommendation on the theft by shoplifting is 12 months served, 30 days, credit for time served. 2 days, $500 fine. Stay away from Walgreens located at 25 Peachtree Street in the anti-theft course.
All right. And Mr. McLean, and we'll now cross the FTA, correct?
Yeah, I'm sorry. That's correct, Your Honor. No process FTA.
Okay. And Mr. McLean, your client has been in custody now for 15 days. So it'll be 12 months to serve 30 days, credit for time served 15 days, and report to probation. I don't see any other holds.
Correct. You don't have any other holes. No. I mean, he is aware of none either.
Okay.
Your Honor, I may end up signing the plea paperwork for him as I flip through the papers. If I have the permission to sign his name for him on the paper.
Okay. Mr. Circuit and Mr. McLean, do you stipulate to the factual basis, venue, and ID?
We do.
Mr. Circuit, have you consumed any medicine or alcohol recently?
No, ma'am.
And are you satisfied with your attorney?
Yes, ma'am.
All right. And have you understood the proceedings so far?
Excuse me?
Have you understood everything so far?
Yes, ma'am.
And you are, is anyone forcing you to take this plea offer today?
No, ma'am.
All right. I want to highlight one important factor over here. You have 2 prior theft by shoplifting convictions on your record. Once I accept your guilty plea to this third charge, or this case, you will have 3 theft by shoplifting convictions on your record. Any new arrest for theft by shoplifting from today onwards is going to automatically be a felony charge. Has that been explained to you?
Oh, yes, ma'am.
And are you still willing to proceed with the plea?
Yes, ma'am.
If you decide to plead guilty, you would have to give up your constitutional right to a trial, to confront your accuser, challenge the state's evidence, examine witnesses, and have the state try to prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to theft by shoplifting?
Guilty.
Your sentence is 12 months to serve 30 days, credit for time served 15 days. You'll be reporting to probation once a month. You have to pay a $500 fine, and you have to stay away from the Walgreens at 25 Peachtree Street. Also, while you're on probation, you're supposed to, you must complete an anti-theft class at your expense. I will require you to report to probation every month. Thank you.
Mr. Circuit, do you recall in my interview you that if you wanted to ask the court to convert any portion of the $500 fine to more community service, that now would be the time to ask? Do you need to call? Do you need to ask the court to do that? Yes, I do. Is it going to be a combo or what? Combo. Your Honor, I think what he'd like to ask the court to do is on the $500 fine, could he make that a $250 fine and a 25-hour community service?
Any objection from the state?
None from the state, Your Honor.
Okay. The $500 fine will be amended to a $250 fine and 25 hours of voluntary community service. You can do the community service anytime during the next 11 months that you're on probation, and the $250 fine must be paid off before the 12 months are up, but you'll report every month. Thank you.
Thank you, Your Honor.
All right, going back to Miss Grace, could you send a message to Mr. Dotis that we are ready to address Jamal English?
Go ahead, ma'am.
Deputy, are these the traffic cases?
Okay, Judge.
Daniel, and Gregory, are they there? All right, don't get him now.
Okay, all right, so those guys.
Valor is,
Okay, so you just all that.
We can let them in at 1 o'clock. I'm just waiting on Mr. English because any word yet, Miss Grace? There we go. All right. Mr. Dotis, you have your client Jamal English, position number 11, the jail code iPhone. This is 23 CR 001867G. Mr. English is accused of battery, domestic violence, and simple battery, domestic violence from November 1st, 2021. Mr. English, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you presently is Mr. Dotis from the Public Defender's Office. Mr. Dotis, it looks, okay, go ahead. What would you like to do today? I'm sorry, Mr. Dotis, you're on mute. I think your audio may be disconnected.
My apologies, Your Honor.
No problem.
Cutting in and out. Yes, Your Honor, this will be a negotiated plea.
All right, Mr. Dotis, you are aware that Mr. English has open felony cases and a bond outstanding in the amount of 90,000.
Yes, Your Honor, I am clear, and I advised Mr. English about that. He indicated to me that he wanted to go forward and resolve this misdemeanor. If he still feels that way, if he feels differently, I'm happy to do what he wants, but I explained all of his options, and this is the choice he made.
All right, I have a Mrs. English on the Zoom. Mrs. English, if you'd like to start your video and unmute, I'll be glad to hear from you if you'd like to say something. Otherwise, I'm moving on with this case.
And Your Honor, the victim in this case is Fantasia Sin.
Oh, yes. Oh, my goodness. Is she still with us? Yes, she is. All right. Mrs. English? Is she still on the Zoom? No, she isn't. All right. Miss Fantasia Sims? Miss Fantasia Sims? All right, she's not responding either. Miss Grace, has Mrs. English gone back into is she in the waiting room?
No, ma'am, I think she went out.
Excuse me. They can hear everything y'all saying.
Is there a Mrs. English? or Fantasia Sims? All right. Mr. English, can you hear me?
Yes.
All right. You do understand that you have open felony cases at the present time,
Yes.
right? You have 23 CP 217247 from an incident date of March 27, 2023, involving trafficking, firearm charges, as well as possession charges. You have another one, 22 SC 184077, involving a charge of aggravated battery, aggravated assault, and possession of firearm by convicted felon from January 2021. In my particular case, you have a battery domestic violence from November 1st, 2021. And what is your intent to do today? Mr. English, what's your intent?
Take the plea.
And you understand that if you decide to take the plea, that you are still incarcerated with a $90,000 bond?
Yes.
Okay. Mr. English, you've been advised of your right to remain silent, and your attorney is Mr. Dotis. Please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
Thank you. Courtroom 2, can we just mute your screen for a minute? I have this background noise. Thank you. All right. Yes, Ms. Duncan, what's the recommendation?
Yes, Your Honor, in this case for counts 1 and 2, battery, family violence, and simple battery, family violence, the state's recommendation is 12 months to serve, 60 days, credit for time served, 22 days, with the balance probated, stay away from the incident location. No further contact with the victim in this case, Fantasia Sims, and a family violence intervention program. The incident location, it occurred at 2265 Perry Boulevard Northwest.
And is that the stay away location? Sorry?
Yes, that is
Okay,
correct.
thank you. Mr. Dotis, does your client accept these terms, and do you stipulate to the factual basis in your ID? What, Mr. English?
If y'all want me to stay away from her, I ain't gonna take the plea, cause that's my fiance and I pay all the bills, I do
Mr.
everything.
English, if you have questions, we'll discuss that. We do have issues with the no further contact, and we were hoping Ms. Sims could shine light on if she wanted to continue having contact. I don't know if ASG Duncan has had contact with the victim and can shine a light on that. If not, because this isn't holding him, I would ask for a reset since Ms. Sims is not on the Zoom today.
I'm going to arraign the case today. We're not going to move forward with a plea. Do you want to file a waiver arraignment, or do we?
Your Honor, I'll file a waiver. I think that's best. Ms. Sims is not here, and this case is not holding him.
All right. Mr. English, your attorney is going to file a waiver of arraignment, which means you're entering a not guilty plea. And because if I sentence you today, you'll be required to stay away from Miss Fantasia Sims for 24 months. It would have been a consecutive sentence.
All right.
All right. So we're not moving. We are going to deem this to be arraigned and further notice for jail jury. Thank you.
Thank you.
All right, that concludes our SAP calendar. We have 9 minutes until we have the scintillating traffic calendar. You all are more than welcome to come and join us to watch that. But in the meantime, everyone, thank you very much. Any questions? Yes, Mr. Dotis, Ms. Strong said, please send documents to her, as well as Mr. McLean, so you can.
Will do.
All right, everyone. Thank you so much. You'll have a good afternoon.
And we send the no cross orders to Ms. Strong, correct?
Yes, state, null pros orders, dismissals. You know, you can send us Kit Kat. She loves Kit Kat. So thank you.